I don't see any reason to change the model charge. I think it's clear. You're telling the jury you can draw an inference.
And then, Your Honor, one area that I think you're going to agree needs to be addressed is we need a better charge language on the preponderance standard. Because at your initial charge on the burden and standards of evidence, you talk about reasonable doubt, but there's a very important shift in the standard which the jury must use to assess the insanity defense. It's a much lower standard of preponderance. And that's why I took the language mostly from the model jury charge, civil jury charge. Charge number 1.12I. And I submitted a red line version so people could see the model language and the language that I proposed to put this into your charge on the insanity defense.
Mr. Shellhorn, what's your position?
Judge, the model charge was adopted, I think, in 1988. If I'm not inaccurate about that, about the insanity, I don't know why there would be a need to start modifying it with this case. There's nothing unique about this case that would call for that.
I agree. The court's charge is directly from the model charge on insanity, model criminal charge.
Well, Your Honor,
As this is a criminal case, not a civil case. And I don't think your proposed charge is particularly neutral. Whereas the model charge is meant to be just that, neutral. Especially as it pertains to the defense of insanity.
Your Honor, I think the fact that the charge hasn't been revised since 1988 is actually a fact to the detriment of its use as written, because what happens frequently with model charges is they don't keep pace with the developments in the law. So I again would advocate...
What's been the development in the law since the model charge was drafted as to preponderance of the evidence? I don't think that's changed since 1988, that the court has a new view of what preponderance of the evidence standard is.
I agree with you.
It's remained the same, and the charges remain the same.
I don't think that the actual law on what constitutes the preponderance of the evidence has changed, but I do believe that the language as written is inadequate to give a non-biased charge on what evidentiary standard the jury should use to decide the insanity defense.
I don't think there's any need for an alteration in the model charge, counsel. Thank you.
Thank you, Your Honor.
All right, you ready for summations?
Yes. Yes, Judge.
At the end of the summations, I'm not sure how long they're going to go. I'll decide whether or not I'll charge this morning or maybe break for an early lunch and then charge this afternoon. I'll make that decision after I hear summations. All right, let's bring the jury in.
got one.
Greer, hold up 1 second, please.
Masks.
Alicia, we need more masks. Do you have another box?
Masks.
Masks. Yeah.
No, you can have it. You got copies of the charge, counsel?
Yes, Your Honor, thank you.
All right, we'll bring the jury in now, Katie, thank you.
Jury entering.
All right, be seated, everyone. Hope everyone had a nice weekend. We're ready to proceed with the trial. We're at the point now where we're going to hear closing arguments, also referred to commonly as summations from counsel. And we'll hear first from the defense, Mr. Belinkis.
Before I start, I'd like to thank you all for your service. The time spent, your attention is greatly appreciated. I know what a huge sacrifice it was for you to serve on this case. This is what makes this country great. This process that we've gone through is what distinguishes us from every other country in the world. It's been an honor and a pleasure to try this case before you. The way this works, ladies and gentlemen, is that I sum up first. The prosecutor goes after me. I will not be able to comment or dispute anything that he says. As the judge told you, and I'm sure he'll tell you again, what the attorneys say is not evidence. Because I can't respond, I'm going to ask you to listen carefully to everything he says. Make sure the evidence supports what he says. Because if you remember in his opening statement, he told you when Michael Barison drove down to the farmhouse and confronted Lauren Kanarek, he was angry. He was furious. Those were his words. I submit there is no evidence whatsoever in this record to support that statement. To the contrary, it's the opposite. Even Robert Goodwin and Lauren Kanarek described Michael Barisone as calm. He used the word sorrowful. It was the defense that brought out that Lauren Kanarek was the one that was pissed. That's her word. She was the one that came stomping down to confront Michael Barisone. She's the one who described herself in her original statement as being Miss Badass. The same description of her conduct with an earlier altercation where she got up into Michael Barisone's face. She pushed him back 20 feet or so. He tried to leave. She prevented him. Remember? She slammed his door shut. He was pleading with her to leave. Those were her words. With respect to the law of insanity, the judge will instruct you. Again, I'd just like to point out that the law recognizes that a forbidden act should not be punished criminally unless done with a knowledge of wrongdoing. If someone is found not guilty by reason of insanity, it does not mean that he will be freed or that he will be indefinitely committed to a mental institution. The court will hold hearings, make determinations as to whether, there are things to adequately protect that person, but more importantly, to protect the public. In my opening statement, I told you what I thought this case was about. Far different than as the prosecutor described it in his statement. After you've seen all the evidence, I hope you agree that it's not a simple cut and dry case as the prosecutor suggested. I submit, ladies and gentlemen, that the state has not met its burden. I submit you should find Michael Barisone not guilty. Clearly, it's horrible that Lauren Kanarek was shot. No person should have to go through that. It's important that you look at the evidence, though. And I submit to you, as I did in my opening statement, that the only evidence as to how the shooting occurred comes from both Kanarek and Goodwin. The investigation starts and stops with them. It stops with Robert Goodwin pointing to Michael Barisone and saying he's the shooter. Two people who I had indicated in my opening, and I believe the evidence has confirmed, have a motive to lie, who have changed their stories, left important things out, important facts, and have now walked into this courtroom, put their hand on this Bible, looked you all in the eyes, and lied to you. The judge is going to instruct you as to a legal concept. It's called false in one, false in all. If you believe that someone intentionally came into this courtroom and intentionally lied about a significant fact, you could disregard their entire testimony. I submit that that's exactly what you should do with Lauren Kanarek and Robert Goodwin's testimony. Before I get into their specific testimony, I'd like to talk to you about the inadequate investigation that I mentioned in my opening statement. Reasonable doubt, the linchpin of the criminal justice system. Reasonable doubt may arise from the evidence itself or the lack of evidence. As I said, the prosecutor's entire case is based on Kanarek and Goodwin. The investigation stopped after Goodwin pointed Barisone out. The evidence is clear that the prosecutor never looked at the events leading up to the incident. The evidence will show that they ignored critical, precise evidence which would have shown you exactly what happened. Evidence that if they had conducted even the most basic scientific analysis, would have addressed many questions, unanswered questions, that I suggest you should have. Instead of doing that, instead of doing a thorough, unbiased investigation, they chose to rely on those two witnesses who clearly have a motive, who admitted in this courtroom to having a plan to destroy Michael Barison and his business. Their whole case with regards to what happened prior to the shooting, when the beating of Michael Barisone occurred, where and when shots were fired, and when a dog attacked Michael Barisone in relationship to the beating that he received. Look, ladies and gentlemen, at the lack of evidence. Ask yourself, what is the most reliable and unbiased piece of evidence in any criminal trial? Video surveillance. You can't change its content. You can't alter it. You can't lie about what's actually depicted. Where's that video? Ask yourself, where is that video? Why didn't the prosecutor or the police seize it on that day? They're asking you to rely solely on the testimony of Robert Goodwin with regards to the content when he turned that off. That's the only evidence that they're asking you to rely on. Clearly, on the night in question, the Washington Township Police Department and the Morris County Prosecutor's Office were made aware of that camera and the possibility that it had captured this entire event. Why didn't someone from Blink testify? There's got to be some record with regards to those cameras. 3 different cameras, according to Goodwin. When was the camera turned on? When was it turned off? What did those cameras capture? How long do those images, are they retained in the cloud? If you turn off an inside camera, as Goodwin said, does that affect and disable the camera outside that would have depicted this entire incident? Where's that testimony, ladies and gentlemen? They're asking you to rely on Robert Goodwin. Doesn't it seem a bit odd, too big of a coincidence, that Robert Goodwin just happened to turn off that video on the day of the shooting? The evidence before you shows that the camera was working on the day before, on the 6th. Recall the testimony about the video capturing Ruth Cox going into the farmhouse the day she got bit by the dog. I submit that's too big of a coincidence for you to rely on, especially when there's been testimony that Lauren Kanarek was talking about finishing Michael Barisone that morning, especially when Kanarek and Goodwin had a discussion a few days before about disarming Michael Barisone's web cameras. Why would anyone, ladies and gentlemen, under any circumstances, want to disable someone else's camera unless they didn't want what they were going to do to be depicted on that. You still want to believe Robert Goodwin? I submit, ladies and gentlemen, that that lack of evidence calls into question the entire sequence of events. I submit, ladies and gentlemen, that that is reasonable doubt. Reasonable doubt begins when the camera is shut off. The prosecutor has to answer that. You should demand a response to those questions. If he says it doesn't matter, I have 2 eyewitnesses, Mr. Belinkas. Question everything else that comes after that. Those witnesses had a plan to destroy Michael Barisone. One of those witnesses is the person who testified was the one who disabled and turned off that camera. Let me throw a little more gas on that fire. When the police get there, no one's holding a gun. The gun is on the ground. Why didn't the police do DNA, fingerprint testing on the gun, the magazine, or the casings? Why didn't they do that gunshot residue on Michael Barisone's hand to determine if he had fired the weapon? You saw in Captain Fellini's affidavit that the judge gave them the right to do that. Why not do that? If you are searching for the truth, do everything. Cross your T's, dot your I's. And why didn't they ask for gunshot residue testing on Kanarek or Goodwin? No. The prosecutor wants you to rely on those witnesses. Let's talk about their crime scene investigation. I submit that the investigation conflicts with Kanarek and Goodwin's testimony. Their version of events. They say 3 shots were fired. Look at the photos and all the evidence that comes before you. They only found 2 shell casings. Where's the 3rd? You can't have a shot without a shell casing. I submit that Kanarek and Goodwin are lying about that 3rd shot. Is it possible, is it conceivable that one of the 2 bullets that had gone through Kanarek's body hit the door? Is that possible? Should anything have been done to try to confirm that or rule that out? If there is no 3rd shot, there is no attempted murder on Robert Goodwin. Let's look at Kanarek's testimony. Again, a witness who admitted on the stand to having a plan to destroy Michael Barison. Stop and think for a second of the magnitude of that statement. Not only was she angry or upset with Michael Barison, but she made a conscious decision to try to destroy someone. Who does that? Who goes to the extent that Lauren Kanarek and Robert Goodwin went to? If you recall Kanarek's testimony, the evidence came out on cross, not on direct with the prosecutor's question that prior to the shooting, she was planning on suing Michael Barisone. I also brought out that she currently is suing Michael Barison and has a financial interest in the outcome. I submit, if you believe Lauren Kanarek walked into this courtroom, put her hand on this Bible, and intentionally lied to you, disregard her testimony. Why do I say that? Now, the judge allowed certain evidence in for a limited purpose to impeach Ms. Kanarek, or evidence that relates to Michael Barisone's state of mind. This is not character evidence. I submit to you, ladies and gentlemen, that Lauren Kanarek lied to you numerous times. Let's go over the lies. Number one, she lied about the recordings. She lied that all the recordings, where she and Goodwin were not present, were recorded from her locker in the stable. And Goodwin jumps in and says the exact same thing, but we'll deal with him in a minute. That statement is clearly a lie. There is evidence in the record that proves she's lying. Recall Robert Goodwin's testimony when he recorded the meeting with Kanarek, the father, and their own lawyer, where they're talking about the recording, and where Kanarek said that all the recordings were done from her locker. And you recall Robert Goodwin's response? At least that one, ha, ha. That testimony, number one, proves that Kanarek is lying about that, I submit, but it also casts doubt on their attorney, Edward David, which I submit to you, you should disregard everything that he says. He was one of the two people that Kanarek said gave him permission to do these secret recordings. When I questioned him or tried to talk to him with regards to anything about these recordings, what was his response? I have no recollection of that. You know, he wanted to stay away, as far away from that as he possibly could. Why? Well, maybe they were illegal. You know, maybe his license may be at jeopardy. He said over and over again, I don't recall having a discussion. Even when I showed him the transcript that I cross-examined Goodwin with, where they talk about the recording and where it's being done. Oh, I don't have a recollection. Oh, it was 2.5 years. He didn't even want to look at the transcript. What does that tell you? And if anyone else, strike that. And further with regards to Davis, when you recall his testimony, he testified on the phone that he heard a struggle. And then he said he testified here, a shot. But in his original statement, he said, clear as a bell, that he didn't know it was a shot. But after talking to everyone, being prepped for trial, he comes in here and testifies under oath that it was a shot. If you need further evidence that Kanarek is lying about those recordings, recall Mary Haskins Graves' testimony, Mary DeFranco's testimony, the attorney for Michael Barison, Stephen Tarshish's testimony. Those three witnesses unequivocally told you that during this time they had private conversations with Michael Barison in the office and in the club room. And that after those conversations, Lauren Kanarek posted their exact words. The office has been testified is over 100 feet away from her locker. The club room is literally 40 feet. Both rooms are separated from Lauren Kanarek's locker by a closed, solid door. Did she lie in this courtroom? I submit there's overwhelming evidence to support that. I submit that she lied about her social media posts. She lied about what she posted and who she posted about. Do you recall her testimony when I confronted her with something that was damaging to what she said and damaging to the prosecutor's case? When I confronted her with her own words, she denied originally making that post. When I walked up, showed her the exact things that she had posted or texted, she said, probably. I counted 16 times she used that word. If she didn't use the word probably after being confronting with her exact words, she said things like, I don't recall if that's what it says. She refused in just about every instance, ladies and gentlemen, to admitting to exactly what she had done and her exact words with regards to that. The only person that does that is someone who's trying to deceive you. Use your common sense. Use the ability that you use every day in your life when someone tells you something and you don't know them. And you consider all the factors that everyone does in making a decision as to whether or not someone is being truthful with you. Is there anyone in this courtroom that if presented with their own exact words on a post or a text would hesitate and accept that that's what you did say? She also lied about not sneaking around in the woods at night. Now, you've heard everything that Lauren Kanarek has done to Michael Barison. You heard from Michael McGrain. Remember, he testified there was one instance where she was in the woods sneaking around. She was dressed in all black with no shoes on. She lied to you. There is evidence that she lied to you. She also lied to you that the reason why she didn't leave was because she couldn't find a place to house her horses and train both her and those horses. You have the sworn testimony of Michael Barisone's attorney, Michael Tarshish's, where he says he told her, I got a place for you. It's right down the road with an Olympic quality athlete to train you and your horses. Lauren Kanarek didn't want to leave. Lauren Kanarek was never leaving that property. Lauren Kanarek was getting free living accommodations. She was only paying for 2 horses. That was a lie to you. She also said she was never officially told to leave. Attorney Steve Tarshish took that stand and said, that's not true. I served an eviction complaint on her. He had the proof of service that she personally received that document. Now, I'm sure the prosecutor is going to say, well, that was a dummy complaint, and I don't even know what he's going to say or comment with regards to it. But the fact is, ladies and gentlemen, she was officially served. Whether it's a dummy complaint or not, she still had an official document to leave. She didn't know it was a dummy complaint before the shooting. She didn't say, well, I got a complaint, and my lawyer looked at it, we checked it. She said, I never was officially served. Lie number 6. Let's go to number 7. Recall her testimony with regards to why she turned Michael Barisone into the town. Remember that 2-page letter that her and Goodwin had concocted? Her testimony to you was that there was a faulty dryer. We were concerned the barn was going to burn down. Do you really think that that was her motivation? Or do you think it was part of her plan, like all these other things, to destroy Michael Barisone? If you're concerned about a faulty dryer, if you're concerned about it possibly starting a fire, pull the plug out. You don't need to write a 2-page letter trying to get Michael Barisone kicked out of his last place of refuge. Do you really, honestly think, ladies and gentlemen, that that was her motivation? A faulty dryer. Based on everything that you know at this point, I submit that she lied to you. Finally, with regards to her bold-faced, despicable lies in this courtroom, is she lied about not searching for DIFUS Anonymous Hotline. Recall her testimony. When I confronted her, did you call DIFUS? No. When I confronted her on the stand with her own phone records indicating that she had searched DIFUS's anonymous hotline on 2 separate occasions, on 2 separate days, what was her response? How could she explain that? Her explanation? Oh, someone must have stolen my phone. And then she tries to blame it on Justin Hardin. Do you honestly believe there's any possibility on the face of the earth to think that Justin Hardin would steal her phone to look something up? Not once, but on 2 separate occasions. If she's lying about this, she's lying about the shooting. She's lying about the incident. If the lies are not good enough for you, good enough to convince you not to believe her, look at her inconsistent statements. And just like you do in everyday conversations, if someone says something one time and then comes back and says something different, don't you normally question the truthfulness of those statements? And again, it depends on the significance, but that's a common thing that all of you do. Look at Kanarek's inconsistent statements. She originally told the prosecutor's office soon after the incident that she disappeared. She doesn't even know where she went. On cross, when I tried to question her with respect to that, she comes up with this crazy story that she meant disappearing in her mind. And then I asked her, did you run away or walk away from the area? And she demonstrated what she claims that she did. She also never mentioned in her original statement that she beat Michael Barisone for 7 minutes. On direct, before I cross-examined her, before I showed her the post in her own words about beating him for 7 minutes, she tried to make light of what she did. She said, I hit him a few times. 7 minutes is not a few times. She testified before you that she had gone up and down the stairs numerous times. She never said that in her original statement, and I'm going to get to that in a second. And I submit, if she did do what she said in this courtroom about going back and forth as she did, that it was before any shot. In her original statement, she said Robert Goodwin was in the house at the time of the shooting. Recall, I brought out that in her statement. She said she ran to the door after being shot and told him not to come out. Now she's saying on direct examination that he was outside. Major inconsistency. What should really bother you, ladies and gentlemen, and I'm going to ask you when you get back in that room and you start talking about things, look at the crime scene photos. The crime scene photos introduced by the prosecutor. And I have one here. What should really bother you is the location of the phones at the crime scene. How did Michael Barisone's phone get on that table? On that round metal table by the bush? No one talked about him having a phone in his hand. Kanarek and Goodwin never talked about Robert Goodwin having a phone. If you're going to shoot somebody, if you're coming down there to kill somebody, why would you have your phone in your hand? How did Michael Barisone's phone get on that table? Was there an argument? Did he try to call 911 like he had done many times and an altercation started? How did Michael Barisone's phone get on that table? More troubling. And I ask you to look at the photographs. How did Lauren Kanarek and Robert Goodwin's phones get at the base of the umbrella stand? Both phones are at the base of the umbrella stands. That is totally inconsistent. That is reasonable doubt. It disputes what Kanarek and Goodwin said. Recall her testimony regarding the use of the phones. This is important, and it should send a shiver up your spine. She says she's holding Robert Goodwin's phone when she's shot. Remember, she's on the phone with her civil lawyer. That should raise a red flag on its own. She says, after being shot, she put the phone down. She walks over climbs up the stairs and grabs her phone. She says she tries to call 911. I don't know why she didn't try to call 911 on Goodwin's phone, but this is her testimony. She says she tries to call 911, her phone doesn't work, she puts it down on the top landing. She walks down the stairs, she walks over to where she placed the phone down by Goodwin and Barisone. She picks up Goodwin's phone, and calls 911. That was her testimony. And you heard the 911 call. At some point during that call, she hands the phone to Goodwin. She then says she walks back up the stairs, retrieves her phone, turns, walks down the stairs, walks over to where Barisone and Goodwin are, and starts beating Michael Barisone with her phone for 7 minutes. So we have the 911 call. We have her beating Barisone in this area. How do the phones get on the umbrella base 10, 12, 13 yards away? All supposedly after being shot. Does that make sense to you? Is it physically impossible for someone to be shot in the chest twice and do all that? Let's look at Robert Goodwin's testimony. I submit, ladies and gentlemen, that based on what you know about Robert Goodwin, that he would do or say anything to help Lauren Kanarek. After all, she's the one paying for everything. She's the one getting them free living accommodations. She's paying him to hang around with the horses. Remember, he is one of the people, him and the father, who had a plan to destroy Michael Barison. He was the one, ladies and gentlemen, that purchased all the recorders and cameras. He was the person that was secreting the recorders and then retrieving them on behalf of Lauren Kanarek. He's the one, ladies and gentlemen, who wrote the letter to the town. He's the one, ladies and gentlemen, that turned off the camera that would have captured this entire incident. In his original statement, he said he only heard shots. In this courtroom, before you, he claims that he actually saw Michael Barisone shooting. Totally different, inconsistent with his statement the night of the incident. Some things that Goodwin did say that are helpful. Michael Barisone was never violent. Michael Barisone never threatened him or Lauren Kanarek. He totally disputed the prosecutor's statement that Michael was angry and furious at the time of the shooting. Described him, as I said, calm and sorrowful. But he also lied to you. He told you the same lie about those recordings. And again, I'm not going to go into the transcript with the lawyer, but clearly, ladies and gentlemen, those recordings were not all made from Lauren Kanarek's locker. In his original statement, he said the same thing Kanarek said in her original statement, that she disappeared. He testified in this courtroom that Kanarek only hit Barisone in the face a few times. That's inconsistent with the 7-minute beating that Kanarek posted about. What's also important, and I don't know how much significance you think this is, neither of them ever mentioned that their dog had attacked Michael Barisone. And we're not talking about a simple nipping. You heard medical testimony from the doctor that treated Michael Barison that he had numerous puncture wounds all over his body. One of which was a puncture wound to his inside groin area. How did that happen? When did that happen? Why didn't Kanarek, why didn't Goodwin ever mention that the dog was mauling Michael Barisone? And what I submit should offend you is the prosecutor introducing a cute photograph of the dog in the background, just sitting up and, very, very calmly. That dog attacked Ruth Cox. That dog attacked Michael Barisone. That dog even attacked the police officer who arrived on the scene. His name is Rosie. I'm calling it Cujo. Why would the prosecutor even think about introducing that photograph? What possible reason other than to try to give you a different impression? The defense put on two highly qualified, distinguished experts. Those two experts, ladies and gentlemen, I believe are far more compelling and believable than the state's one expert. They spent more time with Michael Barisone and did a much more thorough evaluation than the state's doctor, Dr. Schlesinger. Most important, Dr. Simmering saw Michael Barisone soon after the incident, within a month, and he testified, and was never disputed by the state's doctor, that it's important, and you get a better sense of what happened and a better evaluation if you evaluate someone close in time to the incident. Does that make sense to anybody? Is that psychological mumbo-jumbo? It's important that when you're considering these experts, the defense and the state, that you consider that the defense experts do both work for the prosecutor's office and defense lawyers. If you look at Dr. Simmering and his testimony, his credentials were amazing. His experience was amazing. And what's important and what you should consider is that he's been hired numerous times by the Morris County Prosecutor's Office. This office that is prosecuting this case. He's indicated he's been retained. He's been relied on by that office many times. It's going to be interesting to see how the prosecutor attacks him when their office has used him numerous times. Dr. Simmering is a psychiatrist. a medical doctor. He's clearly more educated, has more experience than the state's doctor, Schlesinger, in evaluating people in criminal cases. What's odd, ladies and gentlemen, is that although Dr. Schlesinger, the state expert, says, I disagree with Dr. Simmering's diagnosis, he never explained why or what the basis was. Clearly, he had no problem attacking Dr. Hassan, one of the defense experts, after Dr. Hassan corrected and questioned the method and scoring of the test he gave Michael Barisone. I submit to you, it seemed like almost a personal attack. Like, how dare you question me? When someone says things on the stand like, geez, I don't want to be too critical of someone, and then clearly goes out of their way to attack them, you should question their testimony. The fact is, with regards to the state expert, Dr. Schlesinger, he spent, and I timed it, 45 minutes talking about himself and all his awards. He spent no time telling you why he disagreed with Dr. Simmering. He also testified, and I ask you to recall this point, that he only spent about an hour or so testing Michael Barisone. That's only 15 minutes more than him talking about himself. The state's doctor Dr. Schlesinger said he only spent 13 hours total with Michael Barisone, as compared to 37 hours that Dr. Hassan, one of the defense experts, spent. I submit, ladies and gentlemen, that the state's expert's testimony appeared rehearsed, scripted. How many times did he volunteer things, talk about providing the prosecutor with the articles or books? Oh, I gave you that article, prosecutor, or that book I gave you. I now know where the prosecutor got those articles that he used to try to attack Dr. Hassan. Why would Dr. Schlesinger give those articles and books to Prosecutor Shellhorn when everybody knows, and it's been testified to, there are an equal number of articles and books in the psychiatric field that say the exact opposite thing? Dr. Schlesinger basically is a hired gun for prosecutors' offices in New Jersey and New York. He testified he has another case with this prosecutor's office. He tried to soften that when I had brought out that my experts do work for both sides. Always have, always will. He tried to soften that by saying, well, the first third of my career, I did work for defense lawyers. The second third, I did both. But basically the last third, I'm doing almost exclusively work for the prosecutor's offices. Well, if you divide up that 30-year career, the last 10 years, all he's been doing is rendering opinions for county prosecutors' offices all over the state. And I'm going to ask you to use your common sense. How long do you think he would keep doing that if he didn't support the prosecutor's position? not very long. The fact is, and what the evidence, and he didn't even dispute this, he did shorter versions of the tests he gave. He didn't do anywhere near as many tests as Dr. Hassan did. Dr. Hassan took Schlesinger's data, his results, that he hand scored, and put them into a computer program, and got a totally different profile. A profile that confirmed the delusional disorder that he and Simring had testified to. The exact same data. He didn't make anything up. He took Schlesinger's data that he collected, put it in a program, and got a different result. What does that tell you? Dr. Hassan also did many more tests. He tried to look at this case and the diagnosis from all sorts of different angles. Schlesinger was focused. He had like blinders on. I submit that Dr. Hassan is not only consistent with Simring's diagnosis, but it also provided you with expert testimony concerning a battery of tests, a whole group of tests that he did that are also consistent with that diagnosis. What's really important, and what should bother you, what should cause you to throw out Dr. Schlesinger's entire diagnosis is this. He never talked to Michael Barisone's therapist. Both Hassan and Simring did interviews with the therapist. A therapist that had treated Barisone on and off for 20 years. Schlesinger testified he looked at some text messages between the two, but never talked to her. Never even attempted to talk to her. That, I submit, is important. And why is it important? Because you have two doctors, and it's not disputed, even by Schlesinger, that a person's prior psychiatric history is important. And a person, just like a regular doctor, have you ever had this before? You ever have family members that have had this or that? It's something that's normal in the field, as it is in the medical field. Particularly when formulating a current diagnosis. Both defense doctors had stated that based on that interview, that they were provided with information with regards to Michael's history. They were provided with information that Schlesinger never talked about traumatic events in his life as a child. Both of those doctors said that it's important and may make someone more susceptible to issues later on in life. Is that an outrageous, unreasonable statement? Or is it common sense? Use your everyday experiences. Dr. Schlesinger, the state's doctor, never mentioned that Michael Barisone's mother physically abused him. Never mentioned that Michael Barison was sexually molested over and over again. Dr. Schlesinger never mentioned that his therapist had indicated he had issues with delusions prior to this incident. the same diagnosis or related to the same diagnosis as Dr. Simring and Dr. Hassan had testified to. How can you just leave that out? The state's doctor's position, and we're going to address this, is basically that Michael Barisone's fears are real. That both Barison and other members believe that Lauren Kanarek's threat to kill was real and reality-based. Is he saying that Lauren Kanarek is a danger? Is he saying that Lauren Kanarek and Robert Goodwin had the wherewithal to kill Michael Barisone, his girlfriend, and their children? If that's the case, if that's something that that doctor can glean just from reviewing the police reports as to what happened, why didn't Washington Township Police Department, why didn't the Morris County Prosecutor's Office intercede in the numerous times when Michael Barisone told them he was in fear, told them that Lauren Kanarek was dangerous, tried to show him all the posts and information that Dr. Schlesinger says clearly indicates that she is a danger and a danger is imminent. Remember, those two people are the state's case. Dr. Schlesinger then tries to bolster his opinion by saying, well, because other staff members also felt threatened, that proved his point. That's ridiculous. Ridiculous. Every person is different. You don't need to be a psychiatrist or a psychologist to understand that. Some people are more susceptible to others. Look at all the people that you know. Is somebody stronger? Does someone hear or handle stress differently? Everybody is unique. Past medical history is also important. Dr. Simring, Dr. Hassan testified that past psychiatric history, like prior traumatic events, can cause someone to react differently than someone who didn't have those events. Makes sense? Psychological mumbo-jumbo? As I said, every person is unique. Every person has a breaking point. Some people are stronger than others. The doctors that the defense put on looked at Michael Barisone as an individual differently than Schlesinger's general statements. They said that based on his past mental health issues, that specific things that were done to him caused him to react differently than others. The state's doctor never addressed Michael Barisone's unique circumstances. And again, let me point out an example why I think it's important. Kanarek does something to both Mary Haskins Gray and Michael Barisone. Mary Haskins Gray is afraid. Michael Barisone crawls up in a fetal position, is inconsolable, and is crying hysterically. She testified that that happened numerous times. Clearly, Barisone is in a much different position than Haskins and everyone else at the farm. He's the owner of the farm. It's his business. that they're attacking. Not Grays, not anyone else. He's the one responsible for protecting everyone. Most of the attacks are directed specifically towards him. That he abuses horses, is a criminal, did insurance fraud. That he is the one that has bullied Kanarek and threatened her life. All those false allegations were against him, not anyone else. They have a different impact on him and everyone else. The house that he fled was his house. Haskins was just a girlfriend. No history, no investment in that property. It makes a difference. If I'm some place that I don't own and something happens, I could just leave. It's different when you leave your own house. It causes you to react differently. Michael Barison had no one there to help him or protect him. Mary Haskins Gray had Barison. Mary Haskins Gray had her father come and try to protect him. Michael Barison was in a unique position. Michael Barison was the one that Robert Goodwin took his hand, made it in the gesture of a gun, pulled the trigger, and told him the day before the shooting to get ready. Get ready. Get ready. I submit, ladies and gentlemen, that his unique psychiatric history, the fact that the majority of threats were directed at him and his business, and the fact that he was the sole person responsible, puts him in a much different category. And when you're discussing his mental state and what effect these things had on him, don't go with Schlesinger's general statement that, well, the other people were afraid too. Totally different. No one else, ladies and gentlemen, were calling people to try to get help, like Michael Barisone was. No one fled his own home. No one hired a private investigator to do background checks on them. No one spent $5,000. Think about this. When the prosecutor maybe comes up with some cockamamie story with regards to a financial issue or problem, Steve Tarshis testified that Barison was worth millions. No one else filed a complaint with Safe Sport against Kanarek. Now, I'm sure the prosecutor's going to make some argument with regards to why this happened. If the prosecutor suggests to you that the motive is that Michael Barisone thought a complaint was going to be made against him with Safe Sport, and that's the reason why he wanted to kill Lauren Kanarek, then when he says those words, I want you to think, well, Michael Barisone filed a complaint against Lauren Kanarek. Does she have a motive to kill him? You can't have it both ways. That's what I'm saying. Think about everything that's said to you. No one else called 911 on 4 separate occasions. No one else was turned away and felt as helpless when the police and the Morris County Prosecutor's Office wouldn't help him. Didn't even want to look at the documents, the things that he had masked in this investigation that he was doing on Kanarek. He even personally went to the Washington Township Police Department and tried to plead with them for help. What impact would that have on someone different than everyone else? When you call the people that are supposed to protect you and they do nothing, what impact does that have on someone's state of mind? He also hired a personal security guard, Mr. Davison, to sit excuse me, in his truck to guard the stable area. I submit he had a lawyer write letters and serve a complaint. That, coupled with all the things that Kanarek was doing specifically to him, puts him in a unique category that you should consider. Remember, what was Kanarek's motivation? She admitted to a plan to destroy him and the business. That plan included attacking him on social media, accusing him falsely of neglecting horses, insurance fraud, falsely claiming bullying and threatening her life. She had a plan to scare him. Remember the text that that I questioned her about? We have to scare Michael Barison. And then the various texts after that, where she's talking about Michael Barison being scared. Totally different circumstances. I submit that she had a plan to cause him to flee his own house by scaring him, talking about weapons incessantly, sleeping with a gun underneath her pillow, having 2 guns, 2 9mm guns, talking about killing the king, sacrificing the queen, destroying the castle, talking incessantly about going to war. It's time. War's inevitable. Why would anyone say those things unless they were trying to drive someone over the edge? What possible legitimate purpose would they have attacking him like that? She knew he was emotionally unstable. She knew she was scaring him. She knew that all the things that she was doing, like posting his own words and taunting him with them, would cause him to go insane. Why would someone do that? Take private conversations and use them against that individual. What effect would that have on someone who's becoming emotionally unstable? Does he think he's hearing voices? Does he think everything that he says is being recorded? Is that a rational assumption? Does he know for sure? What effect would that have on someone's mental state? And there's testimony that the majority of that taunting was directed specifically towards him. What would it take for someone to leave their own home? Think about that. What would it take for someone to flee their own home? What effect did Kanarek and Goodwin and the father have on kicking him out of the place that he fled to, the stable area? He's He's now sleeping on a couch, living out of a suitcase in the stable area. She made him homeless. And someone may think or argue, well, you could have just gone to a hotel. That's what one of the town people said. He can't leave his property. He's afraid that Lauren Kanarek, Goodwin, and the father are going to destroy his business. People are afraid that they're going to burn down the barn or hurt their horses. Why is Cox sleeping in front of her horse in the stables? He can't leave all this. This is what he built up from nothing, ladies and gentlemen. He's already fled his house. Do you think it's realistic to think that he would just leave the property and leave it to Kanarek, Goodwin, and the father? You heard testimony from numerous witnesses that he wasn't sleeping. He was wandering the property at night, trying to protect everyone. Who does that? And finally, there's evidence that Kanarek set forth steps to have DCPP come onto the property. Barison told all the experts, the defense and the state expert, that he overheard her talking about sexual misconduct. And that's when he had the breakdown. What's odd, based on Dr. Schlesinger's testimony, is that no one, including Schlesinger, is saying that Michael Barisone is faking his physical and psychological deterioration in the days leading up to the incident. Numerous people took this stand, put their hand on the Bible, and testified to Michael Barisone's decline and failing mental state prior to the incident. It's not something we're setting forth after the fact, prior to the incident. And the prosecutor could have called all these people if he wanted to give you the real picture. All of those witnesses, and I think I put on 23, 24 different people, all of them testified to various observations they made about his decline. Some of them were graphic. I'll name a few. Not sleeping, not bathing, eating, wandering the property at night, unable to carry on a conversation, incapable of handling simple business affairs, crying, sobbing, hysterically in a fetal position. Those people compared Barisone before and after Lauren Kanarek's attacks. He went from this confident, elegant, dignified man to a distraught, disheveled person, pacing aimlessly, mumbling to himself, was described as catatonic. If you recall, the town official, Ms. Gibbs Cook, said on the 6th she could barely recognize who he was from how she had known him before. She described him as undone. Her words. Many of those people who had known him for years, in seeing this decline, thought he was going to kill himself. And numerous people, Olympic athletes, testified that they called and they tried to console him. He was unconsolable. All because of Kanarek, Goodwin, and the father's attacks. Justin Hardin, who was a state's witness, who has known Michael Barisone for 17 years, described him as out of his mind. Others testified he was unable to function. The one thing Justin Harden said, which to me hits home, is Michael Barisone's love for horses, love for riding. He stopped riding. He stopped teaching, training people in horses. That speaks volume as to his mental decline. All these people testified as to Michael Barisone's systematic destruction of him, all at the hands of Kanarek. It was her plan, and her plan worked. They drove him crazy. The state wants you to believe that Michael Barisone, after experiencing this level of deterioration, was capable, after the severe beating that he got from Robert Goodwin, after he was choked unconscious, how somehow, miraculously, he flipped a switch and had the presence of mind to make up a story. I don't remember the event. This is totally inconsistent with every piece of evidence that has been put before you. The prosecutor's going to suggest, I assume, that after all of this, that Michael Barisone should be taken with regards to his statements as an admission of his guilt. When he starts talking about that, recall all the evidence of his mental state when these statements were allegedly made. I submit, ladies and gentlemen, that every single person, the police officers, the medical people that were treating him, everyone had indicated that when Michael Barisone was asked about the events, he had no recollection. So his rambling statements, I had a good life, they destroyed my life, what does that mean? Under those circumstances, in his condition, I submit it's the ramblings from a man suffering from a mental breakdown, a man who's delusional. What's outrageous, ladies and gentlemen, is the prosecutor's attempt to argue that Michael Barisone's statement at the hospital, "I'm sorry," was an admission of guilt. That detective couldn't testify to the circumstances where the statement was made, any context. He didn't even know the exact words. He said, well, words to the effect. What should concern you is that the detective didn't remember who was there, whether or not he was talking to anyone, and doesn't remember the exact words. I ask you to remember that with regard to that statement, "I'm sorry," it was not contained in his detailed notes that he took contemporaneous with everything that was going on. He also never put or testified on direct examination that before that statement, Michael Barisone was injected with 100 milligrams of fentanyl. Fentanyl. Prior to that statement. Why didn't the prosecutor bring that out? Isn't that important? Aren't those details something that you should consider? Before you're deciding whether or not that's an admission of guilt, don't you think you should have all the facts? And even though there is no burden on the defense, I don't need to do or say anything. Don't you think things like that would be important in you assessing what that statement meant? Why is the defense constantly bringing out things differently than what's originally proposed to you? I ask you to recall also that that report was dated over 2 months later. Tried to explain that, well, the report, there's no evidence of that. You have his testimony. The next cop that took the stand, I asked him the same thing with regards to the date of the report, and he says that's when the report was written. What's going on here, ladies and gentlemen? And if you believe what every medical person said about Michael Barisone not remembering the specific incident, I submit you can't be sorry for something you don't remember. And again, this is the linchpin of the state's doctor's diagnosis. That's all he talked about. You have 2 doctors that the defense put on that address this issue. Address, again, the concern of the state doctor that someone charged with a criminal defense may feign symptoms, may fake. Dr. Schlesinger never suggested that Barisone was faking the things that happened to him before the incident. He focused solely on the statement, "I don't remember." Recall the actual testimony, the evidence. The first officer on the scene, Barisone's partially conscious. These aren't defense witnesses, although I had to bring it out. The second officer, incoherent. The third officer, I need to wake up. Is this real? Someone questioning their reality. Every medical person, and the prosecutor was not able to put one person on to dispute this. Every single medical person that talked to Michael Barisone said that he could not recall the event. They described him as confused, and even said he was in an altered mental state. First aid, ambulance people, EMS, hospital personnel, and even the doctor at the jail days later said the same thing. If Michael Barisone wanted to lie about something to protect himself because he's tried with a criminal offense, don't you think, ladies and gentlemen, this bright, intelligent man could come up with something better? Use your common sense. He could have made up a much better story. Kanarek had a gun, I shot her. I was getting the hell beaten out of me. The dog was mauling me. I shot her in self-defense. Don't you think he could have come up with something better than "I don't remember"? That ties his hands. It doesn't help him. It puts me in a position where I'm chasing windmills like Don Quixote. "I don't remember" doesn't help him. What it does, ladies and gentlemen, it gives you a basis to believe Dr. Simmering and Dr. Hassan. If that's not enough, I submit there's overwhelming evidence that that statement is truthful. Both Simmering and Hassan looked at that issue and believe and testify that that loss of memory is real and was either caused by the beating he took to his head or the psychological breakdown. Dr. Hassan even did specific psychological tests to test for feigning. Dr. Schlesinger never did those. Why not? Because it doesn't fit in with his scenario to help the prosecutor. But Dr. Hassan testified that he did those tests, and those tests indicated that there was no feigning. Dr. Schlesinger didn't take those results like Hassan did and say, oh, that's wrong, those are inaccurate. You can't throw out your common sense. You need to look at all the evidence. You need to rely on the most qualified and experienced experts with no agenda. In closing, I ask you to listen carefully to the judge's instruction on insanity. Once the defense establishes by the preponderance of the evidence, the state, as it always does, has the burden of proof beyond a reasonable doubt. That burden never shifts. That is what this country, our legal system, is based upon. I submit, ladies and gentlemen, the defense has established clearly that Michael Barison was insane at the time of the incident. He was suffering from a mental defect, a delusional disorder, and did not know the nature and quality of his actions, and did not know right from wrong. What Lauren Kanarek, Robert Goodwin, and the father did to him was horrible. Horrible. They had a plan to destroy Michael Barison. Don't let them use you to do the job, to finish the bastard. Find Michael Barison not guilty. It is the right and just thing to do. Thank you.
I thank the counsel. Ladies and gentlemen, it's almost 11 o'clock. We'll take our morning recess, then we'll hear from Mr. Shellhorn for the state and his summation. Thank you. Please don't discuss the case.
She told him that he had delusions.
All right, be seated, everyone. All right, we're here now, the summation from the state. Go ahead, Mr. Sheldon.
Thank you, Your Honor. May it please the court, counsel, members of the jury, good morning. If you remember back to my opening statement 2 weeks ago, I told you that I was intentionally leaving things out. And that I was intentionally leaving things out because evidence doesn't come from me, doesn't come from Mr. Belinkis, Mr. Deininger, Mr. Bennett. Evidence comes from witnesses. It comes from people who walk through that door, put their hand on the Bible, take the oath, and agree to testify. So no matter what Mr. Belinkis may have said in his closing, what I may say over the course of the next hour, that's not evidence. The evidence comes from the witnesses. And I start there because your verdict will be based on evidence. It's not going to be based on passion or sympathy or emotion. It will be based on evidence that you heard, evidence that you saw. Mr. Belinkis just spent an hour telling you what he thinks I think, what he thinks I'm going to argue. I hope that I won't leave any questions for you when I'm done. The verdict sheet that you're going to be given has one person's name on it, and that's the defendant, Michael Barison. He's the one person on trial. He's the one person that you're going to go back in that room and deliberate, not about whether you like or dislike Lauren Kanarek, not whether you like or dislike Rob Goodwin, not whether you like or dislike me or Mr. Belinkis, or frankly, whether you like or dislike even the defendant. The verdict sheet is going to ask you whether the defendant is guilty, or not guilty by reason of insanity. Over the course of the next hour, I'm not going to tell you what to think. I'm not going to tell you what to feel. I'm going to point out things that I think the evidence shows, that I think the evidence will help you to decide this case. I don't have any remarkable catchphrases for you. I'm not going to cry. I'm just going to ask you to follow the facts and apply the law. Now, when you all got your jury summons several months ago, you were told what to do, when to log on to your computer, when to have your camera on, when to turn your camera off, when to be in the courthouse, what time to be here, where to go, when you can take a break, when you can talk to people, what you can talk to them about, what you can't. But the one thing that no jury is ever told is how to deliberate. When you go back through that door after Judge Taylor gives you the law, how do you apply the facts and the evidence that you heard to the law the judge is going to give you? So I hope that over the course of this closing argument, I'm going to give you something of a framework. You can use it, you can ignore it, but hopefully it will give you a logical starting point for how to examine those facts and how to apply them to the law. Mr. Belinkis ended his closing by pointing out those burdens of proof. And if you remember back to my opening statement, I told you the burden of proving the defendant guilty rests with Mr. Bennett, it rests with me, it never shifts. That's our burden to prove that the defendant is guilty of attempted murder and of possession of a weapon for an unlawful purpose. So that's where I'm going to suggest that you start your deliberations. But you're also going to hear the judge tell you that the defendant is claiming insanity in this case, and that the burden of proving insanity is on the defendant to prove. That's his burden. So I'll suggest that you address that second. Now, with respect to attempted murder, the judge is going to tell you that a person's use of a deadly weapon allows you to infer that their purpose was to cause death. The reason I start there is because that is such an important part of this case. Why did the defendant use the weapon that he used? It may seem obvious, it may seem simple, it may seem basic, but I'm starting there because he didn't use something that was in his pockets. He didn't use his belt. He didn't use his fists. You heard about the search of his truck. You heard about some of the things that were in the truck. The shovel, the tire iron. Things that when he drove to the house were there in the truck with him. You heard about the patio area. There was a rake there. There's flower pots. There's chairs. There are a number of other things that he could have picked up in that moment. And yet when he got into his truck, when he drove to confront Rob and Lauren, he went there with a deadly weapon. He picked that deadly weapon before he even got in the truck, before he even drove to the house, before he even got out of the car. He had picked that specific deadly weapon. This is the gun. This is the gun that he picked out of his safe to use. And I point that out because you heard testimony, you heard evidence that he had his own guns. He had a .380 caliber, semi-automatic, bless you, handgun in his safe. But what did you hear about that gun? There's no firing pin, there's no extractor, there was no ammunition for that gun. That gun was not an option. You heard about the .45 revolver. But again, you heard that that gun was in the safe, but there was no ammunition for that gun either. And lastly, you heard about his .22 single-action antique revolver. The importance of that being a single action, if you remember the testimony, and if you're not familiar with guns, is that in order for him to fire a shot, you would have to use your thumb to pull that hammer back, to prime it, to get it ready. And then pulling the trigger would shoot a bullet. But to shoot a second bullet, you would have to pull the hammer back again and pull the trigger again. So for each successive shot, he would have had to pull the hammer back and then shoot. You also heard about the way revolvers are loaded, that you don't just put all the bullets in at once, that you have to actually turn the cylinder and put the bullet in, and turn the cylinder again and put the bullet in. It takes longer to load. And that gun, for example, only held 6 bullets. Compare that to the gun he did use. Ruth Cox, 9mm, small, had 2 magazines, one of which was loaded with bullets and that he put into his pocket, making sure that he was taking more ammunition for that deadly weapon with him to the scene. Do you recall when the safe was searched later that day? This is what it looked like. The case where the handgun was, the case that Ruth Cox gave it to him in, with that orange safety magazine in it. The orange safety magazine is out, the 2 magazines are gone, and there's a box of 9mm ammunition right below the gun, open and with bullets missing. Why is this important? Because the judge is going to tell you that just based on the fact that the defendant used a deadly weapon, you can infer that his purpose was to take a life. And he didn't pick up this deadly weapon when he first saw Lauren. He didn't pick it up when he first saw Rob. He didn't pick it up when he first got out of the truck or when he first drove there. He picked it up in the office out of his own safe. He knew when he opened the safe and took that gun exactly what he was going to do. His possession of that gun wasn't accidental, it wasn't incidental, it was purposeful. Now that inference, again, is important because the judge is going to tell you a number of things about the law with respect to attempted murder. But he's going to tell you that essentially Mr. Bennett and I have to prove 2 things to you. First, we have to prove that the defendant's purpose was to cause the deaths of Lauren Kanarek and Rob Goodwin. And second, that he did something that's what's called a substantial step. Again, I'm going to discuss why the evidence shows that the defendant is guilty of this crime. Do you recall where the shooting happened? I'm sure you do. You heard a lot of testimony about it. It didn't happen in the defendant's office. It didn't happen in the barn. It didn't happen at one of these times when Lauren Kanarek was supposedly creeping around and sneaking behind bushes and popping out of the dark. It didn't happen when the defendant just happened to come in contact with her. In fact, you heard testimony that the defendant and Lauren Kanarek had not even seen each other on August 7th. Everything that was going on between them in this week leading up, and on the day that he's charged with trying to kill her, they hadn't even seen each other that day until he went to find her. That's important because Ruth Cox gave the defendant that gun in the stables. And she said that she saw him take that gun back into the clubhouse in the direction of the office, the same place that we just saw
where the gun case was found, where the orange safety magazine was found. The gun was in the office, it was in the safe, it was at the barn. The defendant was last seen in the office at the barn. And yet the shooting happened all the way a quarter of a mile up and down by the farmhouse, a place where the defendant had gotten into his truck and driven to. Before I talk more about the elements of this crime, I do want to discuss credibility. You heard a lot about the credibility of the witnesses. And basically, Mr. Belinkis said, you can't convict the defendant because the only evidence that he's guilty comes from two liars. Two, I think he said, despicable people. They can't be believed. Well, the judge is going to tell you that you're the sole judges of the facts. You decide credibility. Not Mr. Belinkis, not me, not the judge. It's you, the deliberating jurors. And that you do that just the same way you do every single day of your lives. You talk to your spouse, you talk to your kids, you talk to your parents, coworkers, friends. You're evaluating, is what this person telling me reasonable? Is it likely? Is it probable? Lauren Kanarek had 2 bullet holes in her chest. You saw the clothing. There were bullet holes in the clothing. You heard about the testimony about the bullet holes, the bullet hole in the side of the house. And Mr. Belinkis said Lauren Kanarek was shot twice in the chest, and that, like in a cartoon, one of those bullets was able to go out her back and somehow curve up and go out through the top of the house. Does that sound reasonable or probable or likely to you? You heard the testimony, and again, you'll have these exhibits for your deliberations, about where that reconstruction showed that the gun had been shot. That it came in through this door, grazed across this mat, and came at an upward angle through the back window. And if you remember, with the diagram, that basically shows that the gun was shot somewhere in the area of where that bush was. Physical evidence, uncontradicted by anything, that corroborates what Rob and Lauren testified to. You heard about the state of the gun, that when Corporal Heimer gets on scene and he pulls in and he sees 2 men struggling on the ground and he sees a woman bleeding and he rolls the defendant over, and underneath the defendant, not on the ground like Mr. Belinkis would have you believe, underneath 6'4" Michael Barisone's body is the gun. That Rob Goodwin is literally struggling for his life. I'm not exaggerating, that's not hyperbole, I'm not just saying that to make you feel emotional. You heard the 911 call. The 911 call where Rob Goodwin is saying, are you sending anyone? Are you sending help? Hold on, he's moving, he's moving. If you move again, I'll break your arm. His arm isn't broken at that point. Rob Goodwin is saying that while the 911 call is still connected. And then when Corporal Heimer comes in and sees this scene and rolls the defendant over and finds the gun just like that, just like Rob Goodwin testified, when I looked back, I saw the slide was back because the gun was out of bullets. And I was just holding him on the ground, waiting for someone to get there. And Corporal Heimer, who's working a road, third-party road detail or whatever he called it, gets a call that there's an active shooter at this property. And he pulls in by himself, and he says he can't see what's going on in the backyard. There's a huge dually, a big silver pickup truck in the way. And he comes around, and he's got his gun out. He doesn't know what exactly he's going to encounter. And he sees a woman bleeding. And he sees another man saying, this is the shooter, holding him down. And he pulls him off, and he finds a gun underneath his body. And he takes the magazine out, and he throws it. And what does Corporal Heimer say? Not Rob Goodwin saying, if you move, I'll fucking kill you. That's Corporal Heimer saying that. And it's all recorded. You heard it all on the 911 call, which corroborates everything that Rob and Lauren said happened. This attack didn't somehow happen before the 911 call. And then I guess they had time to, walk around and plant evidence in certain places, plant a cell phone in a certain place. Do you remember where the defendant's cell phone was? It's on this table, right here. The exact place where Rob Goodwin and Lauren Kanarek say that they see the defendant. Both of them testified they didn't see him get out of the car. They didn't see when he walked over behind that bush to hide himself behind the bush. They couldn't see if he had anything in his hands. And yet Mr. Belinkis would have you believe that after this shooting happens, that after they beat up Michael Barisone, they're going around planting cell phones in different places. What else did you hear about the scene? Corroborating what Lauren and Rob said. Well, emergency personnel are showing up. Corporal Heimer is there, Officer Wurtenberg's there, Officer Hensley's there, and now it is a free-for-all. There are officers there, there are multiple ambulances there, they're trying to separate people. Isn't it more probable and likely and satisfying to you that somebody moved those cell phones and put them at the base of the umbrella, not Rob Goodwin or Lauren Kanarek? You heard about the weather that day. You heard about the fact that within about an hour of this shooting happening, that the skies opened up, and you saw the pictures. You don't have to take anybody's word for that. You saw pictures of evidence that's literally in inches of standing water because the rain came down so fast and so hard. And Mr. Belinkis says, well, they didn't look for fingerprints on the soaking wet shell casings. They didn't look for fingerprints on this or that. He said they didn't look for gunshot residue. You heard that they looked at the clothing and that it was all soaking wet. You heard that that's a tool that they use. It doesn't show definitively who the shooter is or who the shooter is not. It's a tool that they could possibly use. So back to Lauren Kanarek and Rob Goodwin. Back to credibility. Would it be more satisfying to you if Lauren Kanarek came through that door, came in here, Mr. Belinkis held this up, put her hand on this and said, I'll tell the truth. And then Rob Goodwin said the same. And then they testified to exactly the same words, exactly the same things. Would you feel like that was rehearsed? Like that was fake? Like that was made up? Or do you find it more satisfying that in this unexpected moment, and I'll get to the defendant's state of mind and his emotional state in a moment, but they both describe that he gets there and he's calm. They can't see him, he's hiding behind the bush, and he says words to the effect of, how can we end this without a war? And Lauren Kanarek comes down off the step to talk to him. Then he lifts up a gun, and he points the gun. And when she's no closer than I am to Mr. Belinkis, he starts shooting her in the chest. And Mr. Belinkis says, well, you can't believe anything she says, because at that point, when her body cavities, her torso is literally filling up with blood, her lungs are punctured, you heard that testimony, and her body is filling with her blood as it's pumping, not into her veins, but into her body, that she feels like it's an eternity. You heard her on the 911 call. Was that fake? Was she acting? I've been shot in the heart. Help me. Michael Barisone shot me in the heart. Was that fake? And then Mr. Belinkis did an act where he walked all around the courtroom and showed everything that he thought that Ms. Kanarek was testifying about what she did. I don't remember her reenacting that for us. I don't remember her doing all that. It's your recollection that controls. That's Mr. Belinkis' version of what she testified to. If you think about what she actually testified to, she said, I didn't know where I went. I disappeared. I walked around and I'm patting my chest. She didn't believe that she had actually been shot in that moment. And Rob Goodwin, again in that moment, is struggling for his life. He sees the gun, that picture that we saw where the slide is locked back because it's out of bullets, and he's fighting for his life. And he's just trying to hold the defendant down until police get there. Doesn't all of that corroborate what Lauren and Rob said? The last thing I'll mention is the dog. You heard a ton about the dog in this case. You heard the dog. You heard this vicious, you heard Cujo barking on the 911 call. Barking, yapping. I can tell you when I'm wrestling with my kids, and if the dog is there, the dog jumps in, and the dog is not Cujo. I don't have a vicious junkyard dog. But my dog has a tendency to jump in there and kind of start nipping and getting into the mix with us. Isn't it more logical and probable and reasonable to think that after the defendant had just shot Lauren Kanarek, taken a shot at Rob Goodwin, and Rob Goodwin is literally struggling for his life, that that's when these dog bites occur? Now, the issue of credibility doesn't just apply to Lauren Kanarek and Rob Goodwin. It applies to every witness. So every witness who came in here is subject to you considering, are they worthy of your belief or not? Did they testify with an intent to deceive you? Were they evasive in the way they answered questions? Now, you heard testimony or an argument from Mr. Belinkis about Stephen Tarshis. And I'm sure you all remember when Mr. Tarshis testified. My impressions of Mr. Tarshis are that he was very prepared. He was very professional. He was very knowledgeable about what was going on. And I would submit to you that it was not a mistake that he didn't say anything, not a word on direct examination about that eviction complaint being fake. Mr. Belinkis brought out everything he brought out. He's such a great cross-examiner that he got the truth out for you. Do you remember when Mr. Tarshis testified? Mr. Tarshis testified that on August 5th, he sent a letter to Lauren Kanarek. He sent a letter that basically said, things aren't working out here, you need to leave. He said that letter wasn't signed. And he was asked the question on direct examination, did you send a signed copy to her too? And he said yes. Then he was shown a verified complaint. That's what he called it, verified complaint. He said, yes, I sent this through a courier service or something of that nature on August 6th to Lauren Kanarek. I sent her that eviction notice. That was all the testimony you heard about it on direct examination. And it wasn't until cross-examination, when he was shown a copy of that verified eviction complaint, that he said, well, this was never signed. That wasn't real. Michael Barisone wanted me to send that to scare her into leaving. The man whose defense in this case is that he was crippled by a delusion of fear, such that he had to go and kill or be killed. This same man is telling his lawyer to send Lauren Kanarek a fake eviction notice to scare her to leave. And then that witness left that detail out when he testified on direct examination. You have to question everything that every witness said, not just Lauren Kanarek, not just Robert Goodwin. So the defendant is telling his lawyer, send her a fake eviction. Do you remember when Mary Haskins Gray testified? And I asked her about some of the text messages that she was exchanging back and forth with Michael Barisone in this week leading up. And there was a text message that she had sent to him. It's in evidence. You'll have it for deliberations. Can we please just tell them to leave? Still, no one has told them to leave. And his response was Monday morning. I'll take care of it Monday morning. Meanwhile, he's talking to his attorney behind the scenes. Send her a fake eviction notice. Let's try and scare her to leave the property. And the question was asked, who would do this? Mr. Belinkis said that about Lauren Kanarek over and over and over. Who would do this? Who would do this? He screamed. The defendant is doing the exact same thing to her. What was going on at 411 West Mill Road in August of 2019 is not hard to understand. It's based on emotion. And you all know that because you have life experience. I'm sure you've had disputes with people, disagreements, whether it's at your job, whether it's with a family member, it's at school. You understand how some of these politics work? People don't necessarily want to address something face to face, and so they do it through back channels. So what was going on at this farm, you may not know all of the ins and outs. I think Mr. Tarshish said that the equestrian community was kind of incestuous. So you may not know all the ins and outs of the dressage community. But what was going on there is no different than things that we've all experienced at various points in our life. So take, for example, that there are various levels of rider. You have people like Mary DeFranco, who has the means, she has the wherewithal, the ability to own horses, to own a number of horses, to keep them at farms. She can take off from work for weeks at a time, travel to the farm, go train there, and she basically said she does it as a hobby. She enjoys doing that. And then you have someone like Stephen Tarshish, who testified he's more of an enthusiast. He likes to ride, he said, 5 days a week, 15 hours a week. He said he competes in competitions, but he's also realistic about his capabilities, about his limitations. He knows he's not going to ride in the Olympics, but he just loves it. Then you have people like Lauren Kanarek and Mary Haskins-Gray. These are riders who are training because they do have aspirations to get to those higher levels. And I think you heard Lauren testify. One of the reasons that she didn't really want to or like working with Mary Haskins is because she felt like they were sort of too much of peers. They were too competitive. She wanted a trainer, somebody who had been there, who had been to those highest levels, someone she wouldn't be in direct competition with. And that was one of the reasons she didn't want to work with Mary Haskins. But you have these people who, they do have those aspirations to get to the higher levels. And then at the very top of the sport, you have the people who have been there. Boyd Martin, Philip Dutton, Allison Brock, the Olympians, the Grand Prix, creme de la creme, the internationally known riders. And they all came in and they testified for Michael Barison. They said, we accomplished those things because of this man, because he helped us get to that level. These are his friends. Lauren Kanarek testified that one of the issues that was going on in that week leading up to the shooting is that her career, her riding career, was being threatened. And the very people that the defendant calls to testify in his defense are the elite. They're the people who are at the top, the people with influence, the people with power. And they're here testifying in his attempted murder case about what a great guy he is. He's legendary, he's brilliant, remarkable. Mr. Boyd said, I love the guy. The defendant is sending Mary Haskins text messages that says, I will get her a lifetime ban. He is out to destroy her ability to compete in this sport. And then the people that he calls to testify sit on the USEF Board of Directors. The same agency that the day before the shooting, Mary Haskins is going to the UPS store, making copies of 750-some pages of bad information about Lauren Kanarek, putting in the overnight mail and sending to the USEF. Who would do this? Who would do this? Apparently it wasn't just Lauren Kanarek. The defendant was doing the same things to her. Now, I said before, this wasn't a random shooting. This wasn't just the defendant happening to come across Rob and Lauren in a dark part of the property. And I know that Mr. Belinkis pointed out, well, you had people like Mike McGrain testify. And Mike McGrain said, oh yeah, there was one time that Lauren Kanarek was dressed like a ninja, and she came jumping out of the dark at me, and she had no shoes on, and she had all black on, and it was terrifying. And then I pointed out, the day that this shooting happened, he never said a word of that. He never said a word. Does that make any sense to you? Is that at all satisfying? There's no question these people were not getting along. I am not asking you to go back and deliberate and think that it wasn't on both sides. You heard about all the Facebook posts. You heard about calls to the town. You heard about calls to 911. You heard about the police coming, the town coming. Reports to the USEF, reports to Safe Sport. This is two groups of people that are not getting along and do not like each other. But that's not a delusion. When the defendant went to confront Lauren and Rob that day, he was acting impulsively. He was acting emotionally. But he was acting purposely. And that's the standard for attempted murder. Whether or not the defendant acted with purpose. Did he surrender his restraint to impulse and to emotion? And did he act in that moment without stopping to think? Yes. There's no question about that. That is what the evidence shows. But the evidence doesn't in any way show that Lauren Kanarek and Rob Goodwin lied about when the defendant got out of the car and was holding a gun and pointed it at them and shot at them. And I would submit that the evidence shows the defendant is guilty of those crimes. Now, the second part of where I'm going to suggest that you go during your deliberations is with respect to the defense of insanity. And if you remember, Mr. Belinkis said it, this is the defendant's burden. The judge will tell you this. Mr. Bennett and I, the state bears no burden of proving or disproving that he was insane at the time of the shootings. That's his defense. Even though that was the case, Dr. Schlesinger testified, and I'll talk about him in a moment. But with respect to the defense of insanity, I think it's important to focus in, number one, on the existence of a mental defect. Because the judge is going to tell you that the defendant has to be laboring under a defect of reason from disease of the mind. Now, all the doctors agree that the defendant has depression, he has anxiety, he perhaps has personality disorder, but also agree that none of those mental disorders would affect a person's ability to appreciate the nature and quality of their acts, or to appreciate that what they were doing was wrong. So when you're deliberating, the testimony about the defect of reason relates to that diagnosis of delusional disorder only. Which means that if you don't believe that the defendant can convince you that he has delusional disorder, then you should reject the defense of insanity. And to prove this defense to you, he called two doctors. And Mr. Belinkis called them, I forget what I wrote down, your recollection controls, said that they were both highly qualified, highly decorated doctors. You also heard that they relied on false information. They relied on inaccurate information, incomplete information. You look at experts the same way that you do with lay witnesses, police officers. You evaluate whether you think they testified with an intent to deceive you. And I start there because the defense called Dr. Hassan. Did you think that Dr. Hassan was forthcoming with his answers? Did he seem to be somebody who wanted to say what he wanted to say, regardless of what the question was asking for? I'll suggest that some of his manner of testimony was directly related to the fact that he's not as credentialed as the other doctors. You heard about Dr. Simran, Dr. Schlesinger. They both testified for both the defense and the state. They've both held positions with various organizations. They've published. They're board certified. Dr. Hassan has done none of those things. Do you recall Dr. Hassan's testimony about the DSM? The DSM, the authoritative test for diagnosing mental disorders. That's not me. That's Dr. Simmering and Dr. Schlesinger both testified. This is how you make a diagnosis. It's in its 5th edition. And I asked Dr. Hassan about feigned amnesia. He said, I didn't diagnose feigned amnesia. I diagnosed dissociative amnesia. Feigned amnesia is not a term that appears in the DSM. That's incredible. That's incredible because then you watched as we read together, not from some footnote in the back of the book, not buried on some page related to something unrelated to dissociative amnesia. The page that talks about dissociative amnesia, the same diagnosis.
Judge, I hate to object, that's not in evidence, and he showed it to the jury.
He's referring to it. It was referred to during the testimony of a number of expert witnesses, so it's fair game. It's not obviously going in as a piece of evidence, but it's fair game to comment on by the state. Go ahead, Mr. Shaw.
Thank you, Your Honor. The same diagnosis that Dr. Hassan told you, he gave to the defendant. And then we turned 2 pages, part of that same section, part of that same diagnosis, where it says feigned amnesia is more common in individuals with legal problems. The words feigned amnesia are not only in the book, they talk about the same diagnosis he gave to the defendant. Feigned amnesia, faking amnesia. It got worse. Do you remember what he said then? He said they must have made a mistake. The American Psychiatric Association, in publishing the DSM-5, the 5th edition of this book, they made a mistake. Dr. Hassan doesn't make mistakes. The American Psychiatric Association makes mistakes. Then I asked him about all the things he left out of his report. All the things that he testified to that didn't show up in his report. For example, what about when the defendant first obtained that gun from Ruth Cox? It wasn't that he just obtained it that day, the day of the shooting. He had gotten it from her several days before. He asked her for it. She gave it to him and she never saw it again. It was unloaded. Surely that could have some bearing on the doctor's diagnosis. And he said, well, I did discuss that with him. It's not in his report. And then he said, I didn't think that was important. He said, I ruled out faking amnesia. I gave him a diagnosis of dissociative amnesia. I gave him a diagnosis of delusional disorder. But when he first obtained the gun that he used to shoot 2 people, that has no bearing whatsoever on my report or my opinion. The last thing I'll mention about Dr. Hassan is about the tests. And again, it's your recollection that controls about whether or not the scoring system that he used to score these tests, whether that was valid or invalid. But the fact remains that whether he used a valid test scoring system or an invalid scoring system, he left the results out of his report. He ignored results from the tests he gave when they didn't fit his diagnosis. Results like possibility of defendant malingering, or malingering is likely. Those were results of tests that he gave to the defendant, that he came in and testified about what a great test giver he is, how experienced he is. And yet when the results didn't fit with the diagnosis that he was hired to give, he didn't include them in his report. Judge Taylor is going to tell you as part of that insanity instruction that even the most terrible crimes are committed under the influence of an impulse that overcomes the restraint that ordinarily prevents a person from committing a criminal act. What does that mean? It means that even the most terrible crimes are committed under an emotion, without time to stop and think, and just committed under the influence of that emotion, even though the person ordinarily wouldn't have committed the criminal act. Michael Barisone obviously had restraint on July 31st. He didn't shoot anybody. August 1st, he didn't shoot anybody. August 3rd, 5th, the other days he called the police, he didn't shoot anybody. But he shot 2 people, shot at another person on August 7th. And yet, Dr. Hassan gives a test to the defendant and ignores a result that says impulsiveness, ignores a result that says chooses not to keep or control his emotions in check. He gave the defendant tests that showed that the defendant could have acted impulsively, could have acted under the influence of those emotions, and he didn't put any of it into his report. Why? I would suggest it's because he wanted to deceive you. He was hired by the defendant to give a certain opinion. Was Dr. Schlesinger is a hired gun? How is Dr. Hassan any different? Now, Dr. Simmering is different. Dr. Simmering is obviously testified. You did hear it. He's testified on behalf of defense attorneys, on behalf of prosecutors. He testified or was retained by my office many years ago at some point. But an expert's opinion is no better than the facts on which it's based. His opinion is no stronger than the facts that he has. Imagine a person needs to go to a doctor. It's not in the criminal context, but has to go to a doctor and researches the doctor and tries to find a doctor who's very qualified, has great credentials. Everybody raves about this doctor and how great they are. And so the person goes to see that doctor. Goes in, sees the doctor, and the doctor says, nope, no, too much. Take too much time. I don't want to hear it. I don't need to hear it. Here's your diagnosis. That's basically what Dr. Simmering did in this case. How many times did you hear him say to me, counselor, I'm not going to read all the discovery. Counselor, there's too much discovery to look at. He looked at the things that Michael Barison gave him. He looked at the things that Michael Barison told him were important. And then he came up with a diagnosis just based on that limited amount of information. His report makes that clear, and I hope that it was clear to all of you. I was not pointing out all the inaccuracies or all the errors to embarrass the doctor. That was not my intention. The reason I pointed those out was to point out all the places where he made incorrect assumptions, all the places where his report was inaccurate. Do you remember we talked about he doesn't listen to statements? Dr. Simmering said, I'm not going to listen to all the statements. That would take me too much time. So what did he do? He relied on the police officers' reports where they summarized what they thought the statement said. And then we pointed out his summary of the police officer's summary was inaccurate. He was summarizing the summary differently than it was summarized. I know that's hard to follow, but the takeaway is that he was putting things into his summary that didn't come from the statement. He was putting things in his summary that came from things the defendant told him, things that weren't true. You heard the DCP&P caseworker. She testified that she was there not to investigate a sexual abuse claim. She was there to investigate a child abuse or a neglect claim. That's what she testified to. She wasn't even cross-examined. And yet then Dr. Simmering takes the defendant saying they were there to investigate sexual abuse, and he puts that into his report. And he relies on that, even though it's wrong. It got worse. It got worse just because he was talking about social media posts. Mr. Belinkis did a big deal about these social media posts. Do you remember when Lauren Kanarek was cross-examined about some of her social media posts? Mr. Belinkis pulled out a bunch of different social media posts and he said, didn't you post this? Look out, world, here I come. And she said, yeah, that's from a musical. That's from The Greatest Showman. It's song lyrics. And then we went through the day, she was posting that. She was listening to a Meatloaf song. And then she was posting about some other type of song after that. And yet these are the posts that are supposedly driving Michael Barisone to this delusion of fear. Mr. Belinkis cross-examines her on this post about the guns. This horrible, frightening, terrifying post where Lauren Kanarek says, yes, I do own guns. Do you remember what he left out? Do you remember on cross-examination when Lauren Kanarek read the rest of this post, where it said, they're both in North Carolina? That part was left out on direct cross-examination. We had to clean that up after Mr. Belinkis questioned her, because he left that part of the post out. And then this is the same post that's apparently given by the defendant to Dr. Simmering, where he says, look, Doc, she's posting about guns. I was frightened. I was in a kill or be killed situation. Then I asked the doctor, well, doctor, he gave you that post. He said he relied on that post. He was terrified of Lauren Kanarek because she posted that she had guns. Did you listen to the 911 calls? Yes. Did you listen to the 911 call on July 31st where the defendant is asked, have any guns or weapons been mentioned or threatened? His answer on the call, no. The doctor said he was aware of that. On August 1st, the defendant calls 911. Are any weapons mentioned or threatened? No. The doctor was aware of that call. On August 3rd, the defendant calls 911. Are any weapons mentioned or threatened? Not that I've heard a word of. The doctor was aware of that. And then on August 5th, the defendant calls 911. Were any weapons threatened or mentioned? His answer, not so far. The doctor said that he knew about all of those calls. The week leading up when this delusion has supposedly crippled the defendant into the fetal position, where he believes on August 7th the only thing he can do is take a gun and try to kill Lauren Kanarek because of this delusion. And yet when he's calling 911, he's not saying a word about any of these threatening posts about firearms. And then he tells the doctor, this is what drove my delusion of fear. But perhaps the most troubling thing that came up when Dr. Simring testified was when he was shown a series of what were called posts, social media posts. And he said, yes, these are posts that Michael Barisone gave me. He said he saw these posts, he said he relied on them, and I relied on them. Do you remember on cross-examination, I asked him if he was aware that one of those posts wasn't a post at all. It was actually a private message that came from Facebook that my office turned over to the defendant in discovery. And then the defendant is giving that private message that there is no evidence he could have ever seen before the shooting. He's giving that to the doctor and saying, look what she's posting, look what this says. And then the doctor bases his opinion on that. If you believe that the doctor relied on inaccurate or false or incomplete information, you can discount his entire opinion. And I would suggest that here, neither of the doctors that the defense called are credible. For different reasons, but that their diagnosis of delusional disorder should be rejected. Now, Mr. Belinkus talked about Dr. Schlesinger and said, Dr. Schlesinger's a hired gun. He says whatever we want him to say. He said he didn't even come in and testify why he disagrees about the delusional disorder. My recollection is that he testified to what a delusion is. A delusion is a fixed false belief that's not based in reality. And he said in his opinion, in his review of discovery, all the time he spent with the defendant, there's no evidence that the defendant was disconnected from reality. Everything that he said was connected to reality. Dr. Simring testified a delusion is idiosyncratic. And I said, doctor, what does idiosyncratic mean? It means it's unique to this person. No one else thinks the same thing. And then Dr. Schlesinger said, well, didn't everybody have concerns and fears and find these posts that Lauren was making threatening in some way or another? You heard that testimony. That's not made up. And yet the defendant is the only one that had a delusion, or did everybody have the delusion? Doesn't make sense. The last thing that I'll say about Dr. Schlesinger is that he testified about that issue of malingered amnesia. And if you remember, he basically said malingered amnesia means that the person is faking. And both he and Dr. Simring testified. There is no memory disorder that's selective for criminal behavior. What does that mean? It means there's no memory disorder, whether in the DSM or anywhere, that a person would forget just the time when they're committing a criminal act until they're finished committing a criminal act. There's no memory disorder for that. And yet that's exactly what you have in this case. The defendant has an excellent memory of everything that Lauren Kanarek did to him, of everything that he was feeling and experiencing in that week leading up to the shooting, even up to that morning when the caseworker shows up. And then he stops remembering the moment he puts his hand on a deadly weapon. He stops remembering the moment he loads that deadly weapon and goes to confront her. He stops remembering the part where he shoots her twice in the chest and tries to shoot Rob. And then he doesn't start remembering again until he's at the hospital. And the first thing that he says at the hospital, when he opens up his eyes and he's in the hospital bed and his arm is all bandaged up because it's been broken and he's all beat up, he doesn't say, "Where am I? What am I doing here? How did I get here?" He says, "They destroyed my life. I had a good life and they took it all away." That statement wasn't made in a vacuum. That statement was made after he supposedly doesn't remember shooting these two people. The DSM, feigned or malingered amnesia, says people will often spontaneously confess when they're faking. Was that a spontaneous confession? He didn't have time to necessarily come up with a plan. Mr. Boinga said, "It'd be way better for me. It would be so much better for me if he made up that this was in self-defense." But he didn't do that because that's not what happened. Did the defendant know and appreciate the nature and quality of his acts? That's the other part of the insanity defense. So if you believe that the defendant has convinced you that he was delusional, that's not the end of the inquiry. You still have to decide whether that delusional disorder made it such that he didn't know the nature and quality of his acts, or that he didn't know what he was doing was wrong. And the judge is going to tell you, you do not have to rely just on the doctors for this. You can rely on your common sense. You can rely on the other evidence that you heard. What did the other evidence show? All the same things that established that the defendant wanted to kill show that he knew the nature and quality of his actions. Everything had fallen apart. The working relationship, the business relationship, the social relationship, the farm is getting shut down, police are there, town officials are coming, lawyers are sending fake eviction notices, everything has fallen apart. Then I ask, from a common sense perspective, what's the trigger? What makes it on August 7th, 2019, defendant hasn't seen Lauren or Rob at all that day? What makes the delusion at that point click? Turns off his memory and makes him say, "I have to go kill or be killed." This delusion of fear has now driven me to have to go and kill. It's the DCP caseworker showing up there. Not to say, Lauren and Rob called us and said something about you. The defendant isn't sitting in his office, doesn't look out the window and see a bird flying overhead and believe that the bird was sent to spy on him by Lauren and Rob and that he has to go kill them. He sees the caseworker there, and he decides in that moment to act impulsively, to act emotionally, and to act purposely, and to go try and kill Lauren and Rob. So I would suggest the evidence shows that the defendant did not carry his burden with respect to the insanity defense. So to wrap up, the evidence in this case brings us back to where I started my opening 2 weeks ago. A sprawling, picturesque 50-acre equestrian farm in Long Valley, New Jersey. A place where Lauren Kanarek, who's an aspiring rider, had gone to train. And she didn't just pick this place for no reason. She picked it because of the defendant. She wanted to go there to learn and train and become a better rider. And if you remember the testimony about this picture, she said she did become a better rider. She said this picture was taken after after she had just achieved, I think it was her bronze level or something of that nature. It was a big achievement for her. It was a big step along the way. Did these look like people who always hated each other? Were always scared of each other? They looked pretty genuinely happy in that picture, probably because she had just accomplished something, and the defendant had helped her like he had helped all those other people along the way. Now, on the afternoon of August 7th, 2019, at that farm, a DCP&P caseworker pulls onto the driveway. She pulls up the driveway, she goes past the farmhouse on the left, she goes up over the rise and pulls down into the parking lot. She parks the car in the parking lot in front of that stable and the big clubhouse, all the training arenas nearby, and she gets out and she sees a man. That man turns out to be the defendant, Michael Barison. A great horseman, a very well-respected, highly regarded trainer. A coach and trainer who knows that respect and trust are the keys to success. Who doesn't have any respect or trust anymore for his student, feels like she doesn't have any respect or trust for him anymore. He's frustrated. Furious, you could say. Not frenzied, not frantic, not freaking out, but furious. Maybe seething is a better word. Frustrated, perhaps desperate, emotional. Emotions are not delusions. And he's feeling very emotional at that point in time. When the DCP&P caseworker identifies herself as being from DCP&P, he's at his breaking point. He's not delusional. He's not freaking out. He's reached his breaking point because 2 days before, his mentor, George Morris, another great horseman, had just been given a lifetime ban from equestrian competition. And in that moment, in the parking lot at his farm, he envisions the same fate for himself. He imagines that Lauren Kanarek must have done this. She must have called. She must have reported him for sexual abuse. It's not what happened. That's what he imagines in the light of everything that's going on. And for doing that, she has to die. The caseworker goes inside, and she meets with Mary Haskins, the mother of the children. And the defendant interrupts once, interrupts twice. On the third time, he interrupts and says, "I need the office now. You have to go somewhere else." And on her way out the office, he stops her and he gives her a goodbye kiss. He says goodbye because he knows and appreciates exactly what he's about to do. He goes into the safe, he opens up the safe, and he takes out Ruth Cox's gun. And he loads the bullets in the gun, and he makes sure to take an extra magazine of bullets in his pocket with him. He purposely picks that deadly weapon at that moment because he knows and appreciates exactly what he's about to do. He goes outside, he gets into his truck, and he starts to drive. Starts to go confront Lauren and Rob. And in him going to confront his enemy, he knows and appreciates exactly what he's about to do. He parks the truck, he gets out. He intentionally stands behind a bush where no one can see his waistband, no one can see his pocket, no one can see his hands. And he says to Rob Goodwin, "How can we end this without a war?" He knows that he's armed with a deadly weapon. He knows there will be no war because he's about to commit murder. But he waits. He waits until his enemy, Lauren Kanarek, has stepped down off that step, until she's no closer than Mr. Belinkis is to me right now. And then he hits his breaking point and reaches in and pulls out the gun and shoots her twice. And as Rob Goodwin tries to flee from him, he tries to shoot at Rob, but the gun is out of bullets. None of what I just said was driven by any sort of an emotion, delusion of fear. Everything I just said was driven by the defendant's emotional impulses. So in closing, I would ask that you not return a verdict based on any sympathy, disgust, or emotion, but that you return a verdict that's based on reason, based on facts, and based on the law. And I would suggest if you do that, you will return a just verdict of guilty. Thank you.
Thank you, Mr. Shellhorn. Ladies and gentlemen, it's about 10 after 12. My charge will take a decent amount of time, so I'm going to give you an early lunch break today. You've been sitting all morning. Come back after your lunch break at about 1:15, and I'll give you my charge then, and then we'll select the alternative jurors, and then you'll begin your deliberations. It's important now, you've heard all the evidence, you've heard the summation, but you have not heard my charge on the law, so again, I emphasize to you, please do not discuss the case with yourselves at all. Very shortly, you will be allowed to discuss the case fully and completely in the jury room by yourself with all the evidence. Please don't start any deliberations before that. Enjoy your lunch. We'll see you at 1:15. Rob.
Your notes agree with mine.
And your position is?
Judge, I would maintain my objection that the defendant is trying to offer those statements that he doesn't remember substantively. And I think that the proposed section where it's to add would be regarding statements of a defendant. So I would suggest that the defendant cannot introduce those statements. I would ask that the instruction not be given because it reflects on the substantive nature of the I don't remember.
Counsel, that is a consideration, is it not? Are you saying that these statements were offered by the defense substantively as opposed to their bearing on the state of mind of the defendant?
Your Honor, what I'm saying is that I believe that the charge as written.
No, just answer my question. I know how the charge is written. I ask you a specific question.
Do I believe that those statements were offered for the truth of the matter?
That these statements were offered substantively?
I do.
And how do you get around the hearsay rule for admitting those statements?
Your Honor, the hearsay statements can come in certain circumstances, and I believe that there's an exception applicable to these.
Which is?
State of mind.
Mr. Shellhorn?
I'm looking now, Judge. I'm not sure what subsection specifically counsel's relying on for state of mind.
What's the subsection, counsel, you're relying on?
I don't have a specific subsection, Your Honor, because I don't have the rule in front of me.
See, but you are offering that substantively because the position is he doesn't remember the incident, right? Usually, it is being introduced for his state of mind, but that doesn't mean that you substantively, so the jury can conclude that he did in fact not remember anything.
Your Honor, because the instruction includes specific statements from the officers,
That's
I felt
different.
that we should-
The state introduced those. They're not hearsay. We don't have an issue with that. They're introduced substantively. That much is clear. They're admissible that way. And you're asking that these statements be included as statements of the defendant in a part of the charge that deals with substantive statements of the defendant. So you're offering them for their substance, for the fact that he didn't remember. And as you know, a defendant, if he doesn't testify, the defense can't introduce his statements substantively because he's not subject to cross-examination. So there's got to be an exception to the hearsay rule. And there's present sense impression. I'm not sure it fits under that exclusion, or that exception to the hearsay rule.
Judge, not to split hairs, but I would argue it doesn't apply the present sense impression because it says without opportunity to deliberate or fabricate. And there's at least contradictory or inconsistent testimony here about whether the defendant was faking that or not.
That's an issue in the case, Judge. From the perspective of the prosecutor, that doesn't mean there's evidence sufficient to deem it decided now.
Well, it has to be decided by the court to grant and admit the statement under the legal exception.
Your Honor, I would argue that the decision on that issue is within the province of the jury.
Well, the problem with that section is that it really addresses something that happens contemporaneously as a person is witnessing the event. You know, so a person that would say, you know, oh my God, he has a gun at the time of the shooting would be a present sense impression. It's what they're observing at the time.
I'd agree with that example, Your Honor, but if I may, he's being asked what happened, and his present sense impression upon being asked that question is, I don't know.
He's not perceiving the incident at the time. He's recollecting the incident. That's the difference. Statements that happen when the crime is being committed, if it's a car accident, and someone shouts out as they're witnessing, oh my God, they ran a red light, and it's heard, that's a present sense impression as it's occurring. Not 10 minutes after, when a police officer says what happened, oh, this car ran a red light. That's not a present sense impression. That's after the fact. And I think Mr. Barisone's statements were not made at the time of the shooting, or even immediately after. It was after he was handcuffed. After the scene was secured by police officers, after the medical people arrived. So I don't think it falls under 803C1 as a present sense impression. Nor do I consider it an excited utterance. The only possibility, as I see it, would be under 803C3, Mr. Shellhorn.
Judge, I read that as well, but that also says it does not include a statement of memory or belief to prove the fact remembered or believed. And I realize this is the negative.
Right,
But-
the opposite of that, right?
But I think that the analogy there is the defendant can't just put in a statement that says, well, I don't remember what happened, to prove that I don't remember what happened.
All right, I'll read there's some notes and comments after the rule. I'll read those in detail during the lunch break and then make a decision.
Thank you, Your Honor, and I marked this defense.
And what were the statements again, Mr., it was,
The ones I found, Your Honor, come on day 6.
all right, it's Dan Vitale?
Dan Vitale, Kimberly
And
Held,
what was his purported statement?
that that Michael Barison says, and this is according to my notes, someone was there to take my kids, I can't remember anything else. And I felt that my notes recorded both Vitale and Held testifying to that effect. And when Your Honor's ready,
By Dr. Haney?
Dr. Haney was, do you remember? Answer, no. That's what my notes record.
All right, I'll review it after lunch, thank you.
Thank you, Your Honor.
Oh, now I hear Christina. Okay. Hi, Will. Yeah, I do hear you. Hi, Bob. I'm well. How are you? Good, good. Alrighty. I might go in and get my food and bring it out here. That's how much I'm enjoying this warm weather. Instead of sitting inside. Hey, I can hear you. How are you?
So we don't need to get up at 5:30.
They're asking if you can zoom out just a little bit, please. Right there is good. They said thank you.
No problem.
Hey, Christina, do you have that Amber Heard thing ready to go at the end of the soundbite? Yeah. Okay, great. After the soundbite, yeah. Oh, shoot, I got my earring out.
It's funny when she is. You see it? I go, oh, she told me right after. No, I don't. She goes, well, how do you know the guy? And I was like, it was mine to him. I was like, because there's a lot of people talking about that time he wanted to go out in his last movie. Like, Mom, actually. By the way, I still haven't seen it. Well, Kathy ordered the Jeep for you guys because she mentioned it in. She did, yeah. So, and she did it in like 2 other movies. I was like,
15. Right. Hey, well, good afternoon to you, Bob. You know, we're here in front of the Fairfax County Courthouse where jury selection is underway in the defamation case between Johnny Depp and Amber Heard. Amber Heard, of course, is countersuing Johnny Depp. He is suing her for $50 million. She's countersuing for $100 million, claiming that Depp actually defamed her as well. So she is claiming that he called her a perjurer and a hoax artist, and that she is entitled to damages because of that. So as I mentioned, the jury selection is underway right here, right now in the Fairfax County Courthouse. And this is all traces back to that 2018 op-ed in the Washington Post in which Amber Heard wrote that she had basically survived domestic violence. She didn't name Johnny Depp, but Johnny Depp says that doesn't matter, that everyone knew who she was referring to and what she was referring to. So Depp filed that lawsuit a short time later. He claims that he lost acting roles because he had been labeled a domestic abuser and basically a wife beater. So it's an interesting case, as you mentioned, Bob, because Johnny Depp is a public figure, as is Amber Heard. They're both public figures, so they will both have to prove that there was actual malice here. And we had talked to Gene Rossi, former federal prosecutor. He practices right here in Virginia and is actually a part of a defamation case, representing somebody in a defamation case in this very courthouse right now. And he told me that basically this is a very high hurdle that Johnny Depp is going to have to meet with this defamation case. And then Amber Heard, on the other hand, also has, a high hurdle here because she is a public figure as well. And Gene really likened this to kind of a food fight because all of the dirty laundry is going to come out in this case. So Bob, Amber Heard had actually posted on Instagram recently, just in the last couple of days, saying that she was going offline for a few weeks. This trial is expected to last 6 weeks, and she said she would be doing so because she's going to be facing Johnny Depp in court. She said that she never named him, but that she has paid a high price for challenging men in a position of power. Johnny Depp, meanwhile, maintains that he never abused Amber Heard, that he never punched her or hit her in any way, and that he is innocent of these allegations that she's made against him. So it's very interesting. And we should point out, there have been a lot of people saying and asking, why is this case being held, or why is this lawsuit being filed in the Commonwealth of Virginia? And neither Depp nor Heard live in Virginia. And really the answer to that is pretty simple. It's because the Washington Post is published here in Fairfax County. There are servers for the paper here in Fairfax County, and that is why this defamation suit is being brought here. Interestingly enough, Johnny Depp is not suing the Washington Post. He is only suing his ex-wife, Amber Heard. So Bob, we'll send it back to you. Mm-hmm. I thought you guys said there was no sound. Christina. No, I thought they said there was, I didn't toss to this because they said there was no sound. Somebody said in my ear that, no, somebody said in my ear there's no sound. I thought you were saying there's no Gene sound, or I would have tossed to this. Okay, I thought it was somebody in the booth saying there's no sound, like you didn't have Gene's sound. That's why I didn't toss to this. They're playing Gene saying what I just said. Because somebody said there's no sound. I thought it was a producer saying in my ear we don't have the sound.
By counsel, before we pick the jury in, bring the jury in, with regard to the application by the defense for the admission of certain statements made by, purportedly made by the defendant, with regard to his lack of memory, the defense seeks to include that in the jury charge under pursuant to Rule 803C3. After reviewing that rule and my notes over the break, I am going to exclude that from the jury charge. I don't think it should be included for the following reasons. Number one, the statements were admitted as they pertain to the defendant's state of mind, which clearly is an issue in this case. And they were admitted only for that reason, not as substantive evidence. Now the defense is seeking to have them included as substantive evidence by including them in the section of the charge that deals with statements of the defendant. There's a separate section that deals with hearsay statements of a defendant admitted for the purposes of the psychological examinations and expert testimony as it pertains to insanity. As I understand it, the defense now seeks to introduce those substantively as proof that the defendant did not, in fact, remember the incident from his own mouth. However, that request to treat this evidence now as substantive evidence comes after the close of the evidence in the case. That application, if they wanted to treat it as substantive evidence, they should have made that application before the close of evidence, not as part of the jury charge. That's the first reason. The second reason I'm not including it as part of the jury charge is because under that rule, in order for the court to admit it, I have to find as a condition precedent to admissibility that the statements offered were, quote, made in good faith. And that's supposed to be a determination by the court prior to admission under Rule 104A. However, whether that statement was made in good faith is an issue for the jury to decide in this case. Expert testimony was introduced regarding the defendant's alleged loss of memory and the reasons for it. And the state expert testified that the defendant may have feigned amnesia, that is, that he was malingering his amnesia. Whether the defendant has a memory loss, can't remember the incident, or is malingering is an issue for the jury to decide. So if that's an issue for the jury, I don't see how I can find now that that statement was one that was made in good faith by the defendant based on the testimony. Or it's excludable for that reason as well. And finally, the third reason is that that Rule 803, the exception, I should say, to the hearsay rule, 803C3, specifically excludes, quote, a statement of memory or belief to prove the fact remembered or believed. This is the point Mr. Schellhorn raised. And here it's a little unique because the statement isn't one of memory, but a loss of memory. But the statement holds true. The defense is now seeking to introduce that substantively, a statement regarding memory, in this case a loss of memory, to prove the fact that the defendant can't remember the incident. And that's not allowable under the rule. So I will not include it in that section of the jury charge. Now what is relevant in that section of the jury charge, and I make reference to it, is there's testimony, and this is what I say in the charge in this portion. There was also testimony adduced from various witnesses regarding the defendant's physical injuries and mental status at the time the statements were purportedly made. That's the issue. Because this whole section deals with the credibility of the statement, when it was made, what the circumstances are. And the jury's instructed, you should take into consideration the circumstances and facts as to how the statements were made, as well as other evidence in this case relating to the issue. And it instructs the jury, if after consideration of all these factors you determine the statements were not actually made or that the statements are not credible, then you must disregard the statements completely. So the circumstances of when they were made is something that is significant in the case, and that's why I include that reference to testimony of various witnesses regarding physical injuries and mental status at the time the statements were purportedly made. That draws the jury's attention to something they'd have to consider when they consider those statements, such as what Corporal Heimer said. Officer Wurtenberg made some descriptions of his mental state, Detective Gould as well, Jason Hensley, and then Vitale, Held, and Dr. Haney all made statements in that regard. I think those are somewhat too difficult to mention in detail because there's a lot on direct and cross, and to give a fair assertion of it, I'd have to go into significant detail about what was said. My intent, unless I hear an objection, would be just to draw the jury's attention to those witnesses who commented on the physical and mental condition of the defendant at the scene or at the hospital. Do you have any objection if I do that without getting into the detail?
No, I agree with that, Your Honor.
Counsel?
I understand Your Honor's ruling, and I accept it.
Right. So I'll just mention the names, and I went through all my notes. I'm not going to say these are the only witnesses. I'm going to say including the following. Because I'm not going to tell the jury what they can and cannot consider. I'm going to draw their attention to these because these are reflected in my notes, but I'm not going to get into the specifics of what they said.
Yes, Your Honor.
All right?
Your Honor, I did want to just mark as a proffer Exhibit 10 of today's date, which are the materials they sent over about proposed changes to the jury charge, just so they have it in the record. Thank you.
All right, let's bring the jury in.
Jury entering.
Good afternoon, everyone. Please be seated. All right, ladies and gentlemen of the jury, the evidence in the case has been presented and the attorneys have given their summations to you. We now arrive at the time when you, as jurors, ought to perform your final function in this case. I do have a rather long charge to go through, and then we'll review the verdict sheet in this case. If at any time during my charge to you, you feel the need to stand up and stretch, I will certainly understand. I won't hold it against you, and please feel free to do so. All right, I'm hoping it's an hour or so, maybe a little bit longer, depends on how fast I get through everything I have to tell you. So if you feel the need to stand up, please don't worry, I won't be offended by it. I understand. All right. At the outset, let me express my thanks and appreciation to you for your attention to this case. I would like to commend counsel first for the professional manner in which they have presented their respective cases and for their courtesy to the court and jury during the course of this rather long trial. Before you're retired to deliberate and reach your verdict, it is my obligation to instruct you as to the principles of law applicable to this case. You shall consider my instructions in their entirety and not pick out any particular instruction and overemphasize it. Generally speaking, these instructions consist of 4 parts. The first part deals with the general principles of law that apply to a criminal case. The second part describes the evidence that you may consider in your deliberations. The third part is about the portion of the Criminal Code of New Jersey that you must apply to the facts you find in this case to determine whether the state has proven beyond a reasonable doubt that the defendant violated a specific criminal statute. Finally, the fourth part of the instructions tells you how to go about conducting your deliberations. You must accept and apply this law in this case as I give it to you in this charge. Any ideas you have of what the law is or what the law should be, or any statements by the attorneys as to what the law may be, must be disregarded by you if they are in conflict with my charge. Turning first to the nature of the indictment, the general principles of law that apply to a criminal case, the defendant stands before you on an indictment returned by the grand jury charging him with 2 counts of attempted murder and 2 counts of possession of a weapon for an unlawful purpose. The indictment is not evidence of the defendant's guilt on any of those charges. An indictment is a step in the procedure to bring the matter before the court and jury for the jury's ultimate determination as to whether the defendant is guilty or not guilty on the charges stated in it. The defendant has pleaded not guilty to the charges. The defendant on trial is presumed to be innocent, and unless each and every essential element of an offense charge is proved beyond a reasonable doubt, the defendant must be found not guilty of that charge. The burden of proving each element of a charge beyond a reasonable doubt rests upon the state, and that burden never shifts to the defendant. The defendant in a criminal case has no obligation or duty to prove his innocence or offer any proof relating to innocence. The prosecution must prove its case by more than a mere preponderance of the evidence, yet not necessarily to an absolute certainty. The state has the burden of proving a defendant guilty beyond a reasonable doubt. Some of you may have served as jurors in civil cases where you were told that it is necessary to prove only that a fact is more likely true than not true. Yes, Katie, lock that door. Nobody gets in. Nobody gets out. And if we need an officer stationed outside, officer, I'm sure you have one available for us.
We called someone to lock it. That's,
All right.
yeah.
Sorry about that, folks. The prosecution must prove its case by more than a mere preponderance of the evidence, yet not necessarily to an absolute certainty. The state has the burden of proving a defendant guilty beyond a reasonable doubt. Some of you may have served as jurors in civil cases where you were told that it is necessary to prove only that a fact is more likely true than not true. In criminal cases, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. A reasonable doubt is an honest and reasonable uncertainty in your minds about the guilt of the defendant after you have given full and impartial consideration to all of the evidence. A reasonable doubt may arise from the evidence itself or from a lack of evidence. It is a doubt that a reasonable person hearing the same evidence would have. Proof beyond a reasonable doubt is proof, for example, that leaves you firmly convinced of the defendant's guilt. In this world, we know very few things with absolute certainty. In criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him guilty. If, on the other hand, you are not firmly convinced of the defendant's guilt, you must give the defendant the benefit of the doubt and find him not guilty. The function of the judge is separate and distinct from the function of the jury. It is my responsibility to determine all questions of law arising during the trial and to instruct the jury as to the law that applies in this case. You must accept the law as given to you by me and apply it to the facts as you find them to be. During the course of the trial, I was required to make certain rulings on the admissibility of the evidence, either in or outside of your presence. These rulings involve questions of law. The comments of the attorneys on these matters were not evidence. In ruling, I have decided questions of law, and whatever the ruling may have been in a particular instance, you should understand that it was not an expression or opinion by me on the merits of the case. Neither should my other rulings on any other aspect of the trial be taken as favoring one side or the other. Each matter was decided on its own merits. I may have sustained objections to some questions asked by counsel, which may have contained statements of certain facts. The mere fact that an attorney asks a question and inserts facts or opinions in that question in no way proves the existence of those facts. You will only consider such facts which in your judgment have been proven by the testimony of witnesses or from exhibits admitted into evidence by this court. The fact that I may have asked questions of a witness in this case must not influence you in any way in your deliberations. If I recall, I may have asked a few minor questions, clarification questions for witnesses. The fact that I ask such questions does not indicate that I hold any opinion one way or the other as to the testimony given by that witness. Any remarks made by me to counsel or by counsel to me or between counsel are not evidence and should not affect or play any part in your deliberations. As I instructed you when we started this case, I explained to you that you are the judges of the facts. And as judges of the facts, you are to determine the credibility of the various witnesses as well as the weight to be attached to their testimony. You and you alone are the sole and exclusive judges of the evidence, of the credibility of the witnesses, and the weight to be attached to the testimony of each witness. Regardless of what counsel said, or I may have said recalling the evidence in this case, it is your recollection of the evidence that should guide you as the judges of the facts. Arguments, statements, remarks, openings, and summation of counsel are not evidence and must not be treated as evidence. Although the attorneys may point out what they think important in this case, you must rely solely upon your understanding and recollection of the evidence that was admitted during the trial. Whether or not the defendant has been proven guilty beyond a reasonable doubt is for you to determine based on all the evidence presented during the trial. Any comments by counsel are not controlling. It is your sworn duty to arrive at a just conclusion after considering all the evidence which was presented during the course of the trial. Now I will move on to the second part of the instructions and discuss the evidence that you may consider in judging the facts of this case. When I use the term evidence, I mean the testimony you have heard and seen from the witness box, any stipulation, and the exhibits that have been admitted into evidence. Any exhibit that has not been admitted into evidence cannot be given to you in the jury room, even though it may have been marked for identification. Only those items admitted into evidence can be given to you. And at this point, I do want to advise you of how you will receive those exhibits. And this is because of COVID protocols still in place. You will have this laptop with you in the jury room. There are 2 thumb drives with state exhibits and defense exhibits that both counsel have reviewed. So we know that those are the only exhibits in evidence that you'll be able to review. You can use the laptop and the thumb drives to review all the evidence in the case. Photographs, things of that nature, everything admitted, other than physical evidence, of course, will be on those thumb drives for you to review. When you first retire to the jury room, there will be an IT person that works for the judiciary who will be sworn and will take the laptop and those thumb drives into you and show you how to use them. Although I would guess that most of you probably know how to use a thumb drive and a computer anyway, but just for our peace of mind, he'll go in there and he can answer any questions you have about how to use the computer and view the evidence. All right? And there will be other separate physical evidence that will be moved in. Is that correct, Mr. Shellhorn?
Yes, Your Honor.
Any testimony that I may have had occasion to strike is not evidence and shall not enter into your final deliberations. It must be disregarded by you. This means that even though you may remember the testimony, you are not to use it in your discussions or deliberations. Further, if I gave a limiting instruction as to how to use certain evidence, that evidence must be considered by you for that purpose only. You cannot use it for any other purpose. As jurors, it is your duty to weigh the evidence calmly and without passion, prejudice, or sympathy. Any influence caused by these emotions has the potential to deprive both the state and the defendant of what you promised them, a fair and impartial trial by fair and impartial jurors. Also, speculation, conjecture, and other forms of guessing play no role in the performance of your duty. As I instructed you at the beginning of the case, evidence may be either direct or circumstantial. Excuse me. Direct evidence means evidence that directly proves a fact without an inference, and which in itself, if true, conclusively establishes that fact. On the other hand, circumstantial evidence means evidence that proves a fact from which an inference of the existence of another fact may be drawn. An inference is a deduction of fact that may logically and reasonably be drawn from another fact or group of facts established by the evidence. Whether or not inferences should be drawn is for you to decide using your own common sense, knowledge, and everyday experience. Ask yourselves, is it probable, logical, and reasonable? It is not necessary that all facts be proven by direct evidence. They may be proven by direct evidence, circumstantial evidence, or a combination of direct and circumstantial evidence. All are acceptable means of proof. In many cases, circumstantial evidence may be more certain, satisfying, and persuasive than direct evidence. However, direct and circumstantial evidence should be scrutinized and evaluated carefully. A verdict of guilty may be based on direct evidence alone, circumstantial evidence alone, or a combination of direct and circumstantial evidence, provided, of course, that it convinces you of a defendant's guilt beyond a reasonable doubt. The reverse is also true. A defendant may be found not guilty by reason of direct evidence, circumstantial evidence, or a combination of the two, or a lack of evidence if it raises in your mind a reasonable doubt as to the defendant's guilt. And recall at the beginning of the case I gave an example. I'm not going to repeat it in full here. I'm sure you remember it, of my children going to sleep at night and looking out the window to see if it was snowing before school. They testified they saw snow falling before they went to bed. That's direct evidence. If they didn't see snow on the ground, they didn't see snow falling when they went to bed, but they woke up in the morning, they saw snow covered on the ground. The snow on the ground is a fact established from which they could draw a reasonable logical inference that it had snowed during the night when they slept. All right? Moving on to the credibility of witnesses. As the judges of the facts, you are to determine the credibility of the witnesses, and in determining whether a witness is worthy of belief and therefore credible, you may take into consideration the following: the appearance and demeanor of the witness, the manner in which he or she may have testified, the witness's interest in the outcome of the trial, if any, his or her means of obtaining knowledge of the facts, the witness's power of discernment, meaning his or her judgment, their understanding, his or her ability to reason, observe, recollect, and relate, the possible bias, if any, in favor of the side for whom the witness testified, the extent to which, if at all, each witness is either corroborated or contradicted, supported or discredited by other evidence, whether the witness testified with an intent to deceive you, the reasonableness or unreasonableness of the testimony the witness has given, whether the witness made any inconsistent or contradictory statement, and any and all other matters in evidence would serve to support or discredit his or her testimony. Through this analysis, as the judges of the facts, you weigh the testimony of each witness and then determine the weight to give it. Through that process, you may accept all of it, a portion of it, or none of it. If you believe that any witness willfully and knowingly testified falsely to any material facts in this case, with intent to deceive you, you may give such weight to his or her testimony as you deem it is entitled. You may believe some of it, or you may, in your discretion, disregard all of it. There is, for your consideration in this case, oral statements allegedly made by the defendant. It is your function to determine whether or not the statements were actually made by the defendant, and if made, whether the statements or any portion of them are credible. In considering whether or not an oral statement was actually made by the defendant, and if made, whether it is credible, you should receive, weigh, and consider this evidence with caution, based on the generally recognized risk of misunderstanding by the hearer, or the ability of the hearer to recall accurately the words used by the defendant. The specific words used and the ability to remember them are important to the correct understanding of any oral communications, because the presence or absence or change of a single word may substantially change the true meaning of even the shortest sentence. You should therefore receive, weigh, and consider such evidence with caution. And addressing now the specific statements at issue, we'll call from the testimony Corporal Derek Heimer testified that at the scene of the shooting, defendant allegedly, repeatedly stated, "I had a good life." Police officer Jason Hensley testified that while defendant was in an ambulance being transported from the scene, he allegedly repeatedly stated, "Is this real? I need to wake up." Also, Detective Jason Gould testified he heard defendant make statements while in the ICU unit at the hospital. Detective Gould testified the defendant allegedly stated in sum and substance, "They destroyed my life over the past 6 months. I had a good life. They took it all away," and that he was sorry. In considering whether or not these statements are credible, you should take into consideration the circumstances and facts as to how the statements were made, as well as all other evidence in this case relating to this issue. Among those circumstances, police officer Hensley testified that after taking custody of the defendant at the scene, he advised the defendant of his Miranda rights from a card he carried. Officer Hensley testified the defendant verbally acknowledged his Miranda rights but did not recall whether the defendant indicated he wished to speak to the officer. There was also testimony adduced from various witnesses regarding the defendant's physical injuries and mental status at the time the statements were purportedly made. Those witnesses include Corporal Heimer, Officer John Wurtenberg, Detective Jason Gould, Police Officer Jason Hensley, Mobile Intensive Care Paramedic Dan Vitale, EMT worker Kimberly Held, and Dr. Haney from the hospital. And those are only my recollection. Your recollection controls if there are other witnesses that address the defendant's state of mind, physical condition that may bear upon the statements he made and their credibility. you certainly consider those. You are not limited by that list of witnesses that I just read to you. If, after consideration of all these factors, you determine that the statements were not actually made or that the statements are not credible, then you must disregard the statements completely. If you find that the statements were made and that part or all of the statements are credible, you may give what weight you think appropriate to the portion of the statement you find to be truthful and credible. As you know, the defendant, Michael Barisone, elected not to testify at trial. It is his constitutional right to remain silent. You must not consider, for any purpose or in any manner in arriving at your verdict, the fact that Michael Barisone did not testify. That fact should not enter your deliberations or discussions in any manner or at any time. Michael Barisone is entitled to have the jury consider all the evidence presented at trial. He is presumed innocent whether or not he chooses to testify. Now, in this next section, I'm going to address some limiting instructions. During the testimony of certain witnesses, they may have made reference to the fact that information was obtained from the defendant while he was in custody at the Morris County Jail. The fact that the defendant was detained in this facility at some point is irrelevant and should play no part in your consideration of this case. You may not use this evidence in any way to infer the defendant is guilty of the charges simply because he was in custody. You have also heard references to Lauren Kanarek and Rob Goodwin having used drugs in the past. This testimony was admitted by the court for a limited purpose. Testimony may only be considered for the limited purpose of explaining or supporting the conclusions reached by Dr. Simmering and Dr. Hassan, or for assessing the value of the doctor's opinions that are dependent or rely on this information. You may not consider this testimony for any other purpose. You should not consider the testimony as substantive evidence relating to the guilt or innocence of the defendant, or consider it as reflecting the bad character of Lauren Kanarek or Robert Goodwin. You also heard testimony regarding the purported and unverified prior criminal history of Robert Goodwin and Lauren Kanarek, the defendant received from a private investigator, Joseph Blattler. The defense alleges this information affected the defendant's state of mind. I instruct you that this testimony may only be considered for the limited purpose of explaining or supporting the conclusions reached by Dr. Simmering and Dr. Hassan regarding the defendant's state of mind, or for assessing the value of the doctor's opinions that are dependent or rely on this information. Under our rules of evidence, a jury may consider a witness's criminal conviction in determining the credibility or believability of that witness. However, there is no evidence that Lauren Kanarek or Robert Goodwin has a criminal conviction. You must not consider the testimony related to the alleged prior criminal history as affecting the credibility of Lauren Kanarek or Robert Goodwin. Nor may you consider it as substantive evidence related to the guilt or innocence of the defendant. The only relevance of the evidence is the extent to which you find it may have affected the defendant's state of mind. Similarly, you have heard reference in testimony to Lauren Kanarek owning or possessing a firearm. Again, this testimony was admitted by the court for a limited purpose. Testimony may only be considered for the limited purpose of explaining or supporting the conclusions reached by Dr. Simmering, Dr. Hassan, and Dr. Schlesinger regarding the defendant's state of mind, or for assessing the value of the doctor's opinions that are dependent or rely on this information. You may not consider this testimony for any other purpose. You should not consider this testimony as substantive evidence related to the guilt or innocence of the defendant, or consider it as reflecting the bad character of Lauren Kanarek. Moving on to expert testimony, ladies and gentlemen. As a general rule, witnesses can testify only as to facts known by them. This rule ordinarily does not permit the opinion of a witness to be received as evidence. However, an exception to this rule exists in the case of an expert witness who may give his opinion as to any matter in which he is versed, which is material to this case. In legal terminology, an expert witness is a witness who has some special knowledge, skill, experience, or training that is not possessed by the ordinary juror, and who thus may be able to provide assistance to the jury in understanding the evidence presented and determining the facts of the case. In this case, Detective Andreas Zaharopoulos of the Morris County Prosecutor's Office, I did practice that name over the weekend, ladies and gentlemen. Happy to say I got it remotely correct, close to being correct. Detective Zaharopoulos of the Morris County Sheriff's Office, William Stitt of the Morris County Sheriff's Office, Dr. Stephen S. Simmering, M.D., Dr. Charles S. Hassan, Ph.D., and Dr. Louis B. Schlesinger, Ph.D., were called as experts. You are not bound by such experts' opinions, but you should consider each opinion and give it the weight to which you deem it is entitled, whether that be great or slight, or you may reject it. In examining each opinion, you may consider the reasons given for it, if any, and you may also consider the qualifications and credibility of the expert. It is always within the special function of the jury to determine whether the facts on which the answer or testimony of an expert is based actually exist. The value or weight of the opinion of the expert is dependent upon and is no stronger than the facts on which it is based. In other words, the probative value of the opinion will depend upon whether from all the evidence in this case you find that those facts are true. You may in fact determine from the evidence in this case that the facts that form the basis of the opinion are true, are not true, or are true in part only. And in light of such findings, you should decide what effect such determination has upon the weight to be given to the opinion of the expert. Your acceptance or rejection of the expert opinion will depend, therefore, to some extent on your findings as to the truth of the facts relied upon. The ultimate determination of whether or not the state has proven the defendant's guilt beyond a reasonable doubt is to be made only by the jury. You have heard testimony related to alleged statements made by the defendant during psychiatric and psychological examinations by the three experts, Dr. Simmering, Dr. Hassan, and Dr. Schlesinger. You should not consider these hearsay statements as substantive evidence relating to the guilt or innocence of the defendant, or for the truth of the matter asserted by the defendant in those statements. Rather, I instruct you to consider these statements only for the limited purpose of explaining or supporting the conclusions reached by Dr. Simmering, Dr. Hassan, and Dr. Schlesinger, or for assessing the value of the doctor's opinions that are dependent or rely on the defendant's statements. Evidence of good character or reputation of an accused is always competent in the trial of a criminal action and is entitled to be considered by you. Two defense witnesses, Philip Dutton and Boyd Martin, testified as character witnesses. You, the jury, should consider all of the relevant testimony, including that relating to the defendant's good character or reputation, and if, on such consideration, there exists a reasonable doubt of his guilt, even though that doubt may arise merely from his previous good repute, he is entitled to an acquittal. But if, from the entire evidence in this case, including that relating to good character, you believe the defendant guilty beyond a reasonable doubt, he should be convicted, and the evidence of good character should not alter the verdict. Now I will instruct you on the third part of the instructions, on the portions of the criminal code that you must apply to the facts you find to determine whether the state has proven beyond a reasonable doubt that the defendant violated a specific criminal statute. The statute read together with the indictment identifies the elements which the state must prove beyond a reasonable doubt to establish the guilt of the defendant on each of the counts in the indictment. In addition, you will have the opportunity to consider an offense beside those charged in the, specifically in the indictment. This is what we call a lesser included offense, crime or offense of a lesser degree that are considered to be included within the charges brought in the indictment. I will give you instructions about how to consider the lesser included offense later in my charge. There are, as you know, 4 offenses charged in the indictment. They are separate offenses by separate counts in the indictment. In your determination of whether the state has proven the defendant guilty of the crimes charged in the indictment beyond a reasonable doubt, the defendant is entitled to have each count considered separately by the evidence which is relevant and material to that particular charge based on the law as I give it to you. By turning first to attempted murder as charged in counts 1 and 2 of the indictment. The indictment charges the defendant with the crime of attempted murder in counts 1 and 2. Count 1 of the indictment reads in relevant part as follows. The grand jurors of the state of New Jersey for the county of Morris upon their oaths present that Michael Barisone on or about August 7, 2019 in the township of Washington in the county of Morris purposely did anything which, under the circumstances, as a reasonable person would believe them to be, is an act constituting a substantial step in a course of conduct planned to culminate in his commission of the crime of murder, specifically by attempting to cause the death of Lauren Kanarek, contrary to the provisions of New Jersey Statute 2C:5-1A3 and New Jersey Statute 2C:11-3A1, and against the peace of this state, the government, and dignity of the same. Count 2 of the indictment reads in pertinent part as follows. Grand jurors of the state of New Jersey for the county of Morris upon their oaths present that Michael Barisone on or about August 7, 2019 in the township of Washington in the county of Morris purposely did anything which under the circumstances as a reasonable person would believe them to be is an act constituting a substantial step in a course of conduct planned to culminate in his commission of the crime of murder, specifically by attempting to cause the death of Robert Goodwin, contrary to the provisions of NJS 2C:5-1A3, NJS 2C:11-3A1, and against the peace of this state, the government, and dignity of the same. In order for you to find the defendant guilty of an attempted murder, the state must prove beyond a reasonable doubt that it was the defendant's purpose to cause the death of the victims. More specifically, the law provides that a person is guilty of an attempt to commit the crime of murder if this person purposely did anything which under the circumstances as a reasonable person would believe them to be is an act constituting a substantial step in a course of conduct planned to culminate in his causing the death of the victims. Thus, in order to find the defendant guilty of the crime of attempted murder, the state must prove the following elements beyond a reasonable doubt. First, as to count 1, it was the defendant's purpose to cause the death of Lauren Kanarek. And as to count 2, it was the defendant's purpose to cause the death of Robert Goodwin. Second, the defendant purposely did anything which under the circumstances as a reasonable person would believe them to be is an act constituting a substantial step in a course of conduct planned to culminate in his causing the death of the victim. First, the state must prove that the defendant acted purposely. Purposely means it was the person's conscious object to cause the death of the victim. Whether the defendant's purpose was to cause the death of the victim is a question of fact for you to decide. Purpose is a condition of the mind which cannot be seen and can only be determined by inference from conduct, words, or acts. It is not necessary for the state to produce a witness or witnesses who can testify that the defendant stated, for example, that his purpose was to cause the death of the victim. It is within your power to find that proof of purpose has been furnished beyond a reasonable doubt by inference, which may arise from the nature of the acts and the surrounding circumstances. Such things as the place where the acts occurred, the weapon used, the location, number, and nature of the wounds inflicted, and all that was done or said by the defendant preceding, connected with, and immediately succeeding the events are among the circumstances to be considered. Causing the death of the victim must be within the design or contemplation of the defendant. The use of a deadly weapon, such as a firearm, in itself may permit you to draw an inference that the defendant's purpose was to take a life. A deadly weapon is any firearm or other weapon, device, instrument, material, or substance, which in the manner it is used or is intended to be used is known to be capable of producing death. In your deliberations, you may consider the weapon used and the manner and circumstances of the attack, and if you are satisfied beyond a reasonable doubt that the defendant shot Lauren Kanarek with a firearm and shot at Robert Goodwin with a firearm, you may draw an inference from the weapon used, that is the firearm, and from the manner and circumstances of the attack as to the defendant's purpose. Second, the state must also prove beyond a reasonable doubt that the defendant purposely did anything which under the circumstances as a reasonable person would believe them to be is an act constituting a substantial step in a course of conduct planned to culminate in his causing the death of the victim. However, the step taken must be one which is strongly corroborative of the defendant's criminal purpose. The defendant must be shown to have had a firmness of criminal purpose to cause the death of the victims. Preparatory steps, if any, must be substantial and not just very remote preparatory acts. In order for you to find a defendant guilty of an attempted murder, the state must prove beyond a reasonable doubt that it was the defendant's purpose to cause the death of the victims. The state, however, is not required to prove a motive. If the state has proven the essential elements of the offense beyond a reasonable doubt, the defendant must be found guilty of the offense regardless of the defendant's motive or lack of motive. If the state, however, has provided a motive, you may consider that insofar as it gives you meaning to other circumstances. On the other hand, you may consider the absence of motive in weighing whether or not the defendant is guilty of attempted murder. If, after consideration of all the evidence, you are convinced beyond a reasonable doubt that the state has proved all the elements of the crime of attempted murder, then your verdict must be guilty. If, however, after a consideration of all the evidence, you find the state has failed to prove each and every element of the crime of attempted murder beyond a reasonable doubt, your verdict must be not guilty. I'm going to now address, ladies and gentlemen, the lesser included offense to attempted murder, which is aggravated assault. The law requires that the court instruct the jury with respect to a possible lesser included offense. Even though the offense is not contained in the indictment. Just because the court is instructing you concerning a lesser included offense does not mean that the court has any opinion one way or the other about whether the defendant committed this or any offense. You should consider this offense along with those for which the defendant is indicted. However, you are not to render a verdict on the lesser included offense or answer the questions on the verdict sheet regarding the lesser included offense unless you find the state has failed to meet its burden with regard to the offenses listed in the indictment, namely attempted murder. Regarding counts 1 and 2 of the indictment, you may consider as a lesser included offense the offense of aggravated assault. As I said, however, do not render a verdict on these offenses or answer the questions on the verdict sheet unless you find the state has failed to meet its burden with regard to the offenses in counts 1 and 2, namely attempted murder. The relevant section of our statute dealing with aggravated assault reads as follows. A person is guilty of aggravated assault if he attempts to cause serious bodily injury to another or causes such injury purposely or knowingly under circumstances manifesting extreme indifference to the value of human life, recklessly causes such injury. Under this statute, the defendant can be found guilty if he either caused serious bodily injury to another or attempted to cause serious bodily injury to another. To find a defendant guilty of aggravated assault for causing serious bodily injury to another, the state must prove beyond a reasonable doubt each of the following elements. Number 1, that the defendant caused serious bodily injury to another. And number 2, that the defendant acted purposely or knowingly or acted recklessly under circumstances manifesting extreme indifference to the value of human life. The first element that the state must prove beyond a reasonable doubt is that the defendant caused serious bodily injury to another. Serious bodily injury means bodily injury which creates a substantial risk of death or which causes serious permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ. The second element that the state must prove beyond a reasonable doubt is that the defendant acted purposely or knowingly or acted recklessly under circumstances manifesting extreme indifference to the value of human life. A person acts purposely with respect to the result of his conduct if it is his conscious object to cause such a result. A person acts purposely if he acts with design, with a specific intent, with a particular object or purpose, or if he means to do what he does, e.g., I did it on purpose. A person acts knowingly with respect to the result of his conduct if he is aware that it is practically certain that his conduct will cause such a result. A person acts recklessly with respect to the result of his conduct if he consciously disregards a substantial and unjustifiable risk that the result will occur from his conduct. The risk must be of such a nature and degree that, considering the nature and purpose of the actor's conduct and the circumstances known to the actor, its disregard involves a gross deviation from the standard of conduct that a reasonable person would observe in the actor's situation. One is said to act recklessly if one acts with recklessness, with scorn for the consequences, heedlessly, foolhardily. The phrase, under circumstances manifesting extreme indifference to the value of human life, does not focus on the state of mind of the actor, but rather on the circumstances under which you find that he acted. If, in light of all the evidence, you find that the conduct of the defendant resulted in a probability as opposed to a mere possibility of serious bodily injury, and you may find that he acted under circumstances manifesting extreme indifference to the value of human life. In determining whether the defendant acted purposely or knowingly, or acted recklessly under circumstances manifesting extreme indifference to the value of human life, you may consider the nature of the acts themselves and the severity of the resulting injuries. If you find that the state has proved each element beyond a reasonable doubt, then you must find the defendant guilty. All jurors do not have to agree unanimously concerning which form of serious bodily injury aggravated assault is present, so long as all believe that it was one form of serious bodily injury or the other. However, for a defendant to be guilty of serious bodily injury aggravated assault, all jurors must agree that the defendant either knowingly or purposely or recklessly under circumstances manifesting extreme indifference to the value of human life, cause serious bodily injury to Lauren Kanarek as to count 1 and Robert Goodwin as to count 2. If you find that the state has failed to prove any element beyond a reasonable doubt, then you must find the defendant not guilty of the charge of aggravated assault in that he caused serious bodily injury to another. As I previously instructed you, the defendant can be found guilty if he either caused serious bodily injury to another or attempted to cause serious bodily injury to another. To find the defendant guilty of attempting to cause serious bodily injury to another, the state must prove beyond a reasonable doubt that the defendant purposely attempted to cause serious bodily injury to another. If you find beyond a reasonable doubt that the defendant attempted to cause serious bodily injury, it does not matter whether the injury actually resulted. The law provides that a person is guilty of attempt if acting purposely he did anything that under the circumstances as a reasonable person would believe them to be was an act constituting a substantial step in a course of conduct planned to culminate in his commission of the crime. The step taken must be one that is strongly corroborative of the defendant's criminal purpose. The accused must be shown to have a firmness of criminal purpose in light of the steps he had already taken. These preparatory steps must be substantial and not just very remote preparatory acts. Again, serious bodily injury means bodily injury which creates a substantial risk of death or which causes serious permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ. And again, a person acts purposely with respect to the result of his conduct if it is his conscious object to cause such a result. A person acts purposely if he acts with design, with a specific intent, with a particular object or purpose, or if he means to do what he does, e.g., I did it on purpose. If you find that the state has proved beyond a reasonable doubt that the defendant attempted to cause serious bodily injury to another, then you must find the defendant guilty. If you find that the state has failed to prove beyond a reasonable doubt that the defendant attempted to cause serious bodily injury to another, then you must find the defendant not guilty. I'm going to move on now, excuse me, to the third and fourth counts of the indictment that charge the defendant, Michael Barisone, with the crime of possession of a firearm with a purpose to use it unlawfully against the property of the person, against the person or property of another. Count 3 of the indictment charges in relevant part the grand jurors of the state of New Jersey for the county of Morris upon their oaths present Michael Barisone on or about August 7, 2019 in the township of Washington in the county of Morris knowingly and unlawfully did possess a certain weapon, to wit, a Ruger 9mm handgun, with a purpose to use it unlawfully against the person or property of Lauren Kanarek, contrary to the provisions of NJS 2C:39-4A1, and against a piece of this state, the government, and dignity of the same. Count 4 of the indictment charges the same crime, but as it pertains and uses the same language. The only difference is count 4 pertains to the use of the firearm unlawfully against the person or property of Robert Goodwin, contrary to the same provisions as listed in count 3. The relevant statute on which this count of the indictment is based reads in pertinent part as follows. Any person who has in his possession any firearm with a purpose to use it unlawfully against the person or property of another is guilty of a crime. In order for you to find a defendant guilty of this charge, the state has the burden of proving beyond a reasonable doubt each of the following 4 elements. Number 1, Exhibit S-177 in evidence is a firearm. Excuse me. Number 2, the defendant possessed the firearm. Number 3, the defendant possessed the firearm with the purpose to use it against a person or property of another. And number 4, the defendant's purpose was to use the firearm unlawfully. The first element the state must prove beyond a reasonable doubt is that Exhibit S-177 is a firearm. A firearm means any handgun, rifle, shotgun, machine gun, automatic or semi-automatic rifle, or any gun, device, or instrument in the nature of a weapon from which may be fired or ejected any solid projectable ball, slug, pellet, missile, or bullet, or any gas, vapor, or other noxious thing, by means of a cartridge or shell, or by the action of an explosive or the igniting of flammable or explosive substances. It shall also include, without limitation, any firearm which is in the nature of an air gun, spring gun, or pistol, or other weapon of a similar nature in which the propelling force is a spring, elastic band, carbon dioxide, compressed or other gas or vapor, air or compressed air, or is ignited by compressed air, and ejecting a bullet or missile smaller than 3/8 of an inch in diameter with sufficient force to injure a person. The second element that the state must prove beyond a reasonable doubt is that the defendant possessed the firearm. To possess an item under the law, one must have a knowing, intentional control of that item accompanied by knowledge of its character. So, a person who possesses an item, such as a firearm, must know or be aware that he possesses it, and he must know what it is that he possesses or controls. That is, a firearm. Possession cannot merely be a passing control, fleeting, or uncertain in its nature. In other words, to possess an item, one must knowingly procure or receive an item or be aware of his control thereof for a sufficient period of time to have been able to relinquish his control if he chose to do so. The state must prove beyond a reasonable doubt that a possessor acted knowingly in possessing the item. A person acts knowingly with respect to the nature of his conduct or the attendant circumstances if he is aware that his conduct is of that nature or that such circumstances exist, or he is aware of the high probability of their existence. A person acts knowingly as to a result of his conduct if he is aware that it is practically certain that his conduct will cause such a result. Knowing with knowledge or equivalent terms have the same meaning. Knowledge is a condition of the mind. It cannot be seen. It can only be determined by inferences from conduct, words, or acts. Therefore, it is not necessary for the state to produce witnesses to testify that a particular defendant, stated, for example, that he acted with knowledge where he had control over a particular thing. It is within your power to find that proof of knowledge has been furnished beyond a reasonable doubt by inference, which may arise, from the nature of the acts and the surrounding circumstances. A person may possess a firearm even though it is not physically on his person at the time of the arrest, if he had in fact at some point prior to his arrest had control over it. Possession means a conscious, knowing possession, either actual or constructive. A person is in actual possession of an item when he first knows what it is, that is, he has knowledge of its character, and second, knowingly has it on his person at a given time. The law recognizes that possession may be constructive instead of actual. A person with knowledge of its character knowingly has direct physical control over an item at a given time, is in actual possession of it. Constructive possession means possession in which the possessor does not physically have the item on his or her person, but is aware that the item is present and is able to and has the intention to exercise control over it. So, someone who has knowledge of the character of an item and knowingly has both the power and the intention at a given time to exercise control over it either directly or through another person or persons, is then in constructive possession of that item. The third element that the state must prove beyond a reasonable doubt is that the defendant's purpose in possessing the firearm was to use it against the person or property of another. Purpose is a condition of the mind which cannot be seen and can only be determined by inferences from words, conduct, or acts. In determining the defendant's purpose in possessing the firearm, you may consider that a person acts purposely with respect to the nature of his conduct or a result of his conduct if it is his conscious object to engage in conduct of that nature or to cause such a result. That is, a person acts purposely if he means to act in a certain way or to cause a certain result. A person acts purposely with respect to attendant circumstances if the person is aware of the existence of such circumstances or believes or hopes that they exist. The defendant's purpose or conscious object to use the firearm against another person or the property of another may be found to exist at any time he is in possession of the object and need not have been the defendant's original intent in possessing the object. The fourth element that the state must prove beyond a reasonable doubt is that the defendant had a purpose to use the firearm in a manner that was prohibited by law. I have already defined purpose for you. This element requires that you find that the state has proven beyond a reasonable doubt that the defendant possessed a firearm with the conscious, objective, design, or specific intent to use it against the person or property of another in an unlawful manner as charged in the indictment, and not for some other purpose. In this case, the state contends that the defendant's unlawful purpose in possessing the firearm was to use it to shoot Lauren Kanarek and or shoot at Robert Goodwin. You must not rely upon your own notions of the unlawfulness of some other undescribed purpose of the defendant. Rather, you must consider whether the state has proven the specific unlawful purpose charged. The unlawful purpose alleged by the state may be inferred from all that was said or done and from all of the surrounding circumstances of this case. However, the state need not prove that the defendant accomplished his unlawful purpose in using the firearm. If you find that the state has failed to prove any of the elements of this crime beyond a reasonable doubt, your verdict must be not guilty. On the other hand, if you are satisfied that the state has proven each and every element of the crime charged beyond a reasonable doubt, your verdict must be guilty. All right, ladies and gentlemen, I'm going to move on to the charge regarding insanity. Apart from his general denial of guilt, the defendant maintains that he is not guilty of the crimes charged in the indictment or the lesser included offense by reason of insanity. If you find that the state has failed to prove beyond a reasonable doubt any essential element of the offense or the defendant's participation in the offense, you must find the defendant not guilty, and you need not consider the evidence as to the defendant's insanity. If you find that the state has proved beyond a reasonable doubt each essential element of the offenses, either those charged in the indictment or the lesser included offense, and the defendant's participation in the offense, you must then consider evidence as to the defendant's insanity. All persons are assumed capable of committing crimes. Insane persons, however, are not capable of committing crimes. It is therefore necessary for me to instruct you with respect to the law of insanity, so far as it relates to the responsibility of a person for the commission of a crime. First of all, the law entertains no prejudice against the defense of insanity. On the contrary, if the defense of insanity is sufficiently established, the law allows the defendant the benefit of it by an acquittal of all criminal responsibility. To consider this defense, it is necessary that you understand the law's concept of criminal responsibility. Our society and our law recognize that some people may be bad and some people may be sick. A hostile act, that is an illegal act, may be one, let me start over. A hostile act, that is an illegal act, may in one case spring from wickedness and in another from some infirmity or sickness of the mind, which the individual did not design. It is society's moral judgment, recognized by our law, that a forbidden act should not be punished criminally unless done with a knowledge of wrongdoing. The law, however, from considerations of public policy, the welfare of society, and the safety of human life, proceeds with care, requiring that the proof of such a defense of insanity be established consistent with a standard recognized by law. Under our law, all persons are assumed to be sane and therefore responsible for their conduct until the contrary is established. Insanity is an affirmative defense, and the burden of proving it by a preponderance of the evidence is on the defendant who asserts the defense. If there is no preponderance of evidence of insanity, the defense of insanity fails, and the defendant stands in the position of a sane individual responsible on all the evidence in this case for his acts, whatever you may find them to have been. The law adopts a standard of its own as a test of criminal responsibility, a standard not always in harmony with the views of psychiatrists. If at the time of committing the act, the defendant was laboring under such a defective reason from disease of the mind as not to know the nature and quality of the act he was doing, or if the defendant did know it, that he did not know what he was doing was wrong, the defendant was then legally insane and therefore not criminally responsible for his conduct. As you can see, the law regards insanity as a disease of the mind. It may be temporary or permanent in its nature, but the condition must be a mental disease. An accused may have the most absurd and irrational notions on some subject. He may be unsound in mind and be a fit subject for confinement and treatment in a mental hospital. But if at the time of the offenses, the defendant had the mental capacity to distinguish right from wrong and to understand the nature and quality of the act done by him, he is subject to the criminal law. These principles must necessarily be the governing principles in the administration of the criminal law, or the most terrible crimes would not be punishable, for such crimes are almost always committed under the influence of an impulse which overcomes the restraint which usually prevents the commission of a crime. Therefore, to establish insanity as a defense to the criminal charge in this case, the defendant must prove by a preponderance of the evidence that defendant was laboring under such a defective reason from disease of the mind as to not know the nature and quality of the act, or if defendant did know it, that he did not know that what he was doing was wrong. The term preponderance of the evidence means a greater weight of credible evidence in this case. It does not necessarily mean the evidence of the greater number of witnesses, but means that evidence which carries the greater convincing power to your minds. Keep in mind, however, that although the burden rests upon the defendant to establish the defense of insanity by a preponderance of the credible evidence, the burden of proving the defendant guilty of the offenses charged here beyond a reasonable doubt is always on the state, and that burden never shifts. The question is not whether the defendant, when he engaged in the deed, in fact actually thought or considered whether the act was right or wrong, but whether the defendant had sufficient mind and understanding to have enabled him to comprehend that it was wrong if defendant had used his faculties for that purpose. to determine whether the defendant has established by the preponderance of the credible evidence that at the time of the commission of the alleged offense, defendant was laboring under such a defect of reason from disease of the mind as not to know the nature and quality of the act he was doing, or if defendant did know it, that he did not know what he was doing was wrong, you should consider all of the relevant and material evidence having a bearing on his mental condition, including his conduct at the time of the alleged act, his conduct since, any mental history, any lay and medical testimony which you have heard from witnesses who have testified for the defense and for the state, and such other evidence by the testimony of witnesses or exhibits in this case that may have a bearing upon and assist you in your determination of the issue of his mental condition. There is a conflict of medical testimony, and you will have to determine where the truth lies. As is true with all issues of fact, the issue is for you to resolve after a careful consideration, comparison, and evaluation of all the evidence which is material to or relevant on the issue of defendant's sanity. The assumed sanity of the defendant is not overcome until you determine that the defendant has sustained his burden of proving by a preponderance of the evidence that at the time of the offense alleged, defendant was insane under the legal definition of insanity and therefore is absolved of criminal responsibility for conduct for which he would otherwise be criminally responsible under the law. The jury is the sole judge of the weight to be given to lay and psychiatric testimony. Generally speaking, no distinction is made between expert testimony and evidence of another character. The same tests that are applied in evaluating lay testimony may be used in judging the weight and sufficiency of expert testimony. You are the sole judges of the credibility of the medical witnesses as well as all other witnesses, and the weight to be accorded to the testimony of each. You saw and you heard them. You had the opportunity to observe their attitude and demeanor on the witness stand. You had the opportunity to hear their means of obtaining knowledge of the facts and to notice their power of discernment, their candor or evasion, if any, and the general and special professional and expert qualifications and background. These factors, any possible bias in favor of one side for whom each testified, and any other matters which serve to illuminate the statements of each may all be considered by you in determining the credibility of the expert testimony and the weight to be accorded it or any part of it. The medical experts have testified that statements were made to them by the defendant, which statements were part of the history they secured from the defendant. As I have previously instructed you, these statements should not be considered as substantive evidence against the defendant relating to his guilt or innocence of the alleged offense, but only as evidence tending to support the ultimate expert conclusion of the psychiatrist or psychologist receiving the history on the test of insanity. The witness, in effect, is not saying that such history is true. The witness is merely testifying that the statements comprising the history were made to him. You may, in fact, determine from the evidence in this case that the facts set forth in such history are true, not true, or true in part only, and in light of such findings, you should decide what effect such determination has upon the weight to be given to the opinion of the expert. However, if a medical expert has testified that his opinion hinges upon the truth of the matter asserted by the defendant at the time the defendant gave the history to the doctor, the probative value of the psychiatrist's opinion or the psychologist's opinion will depend upon whether from all the evidence in the case you find that those facts are true. The same is true for any other facts relied upon by the expert. If the doctor has decided that he accepts as true certain facts on which the doctor bases his opinion, your acceptance or rejection of the doctor's opinion will depend to some extent on your findings as to the truth of these facts. With regard to the verdicts here, you may return one of three verdicts. The first is not guilty, The second is guilty, and the third would be not guilty by reason of insanity. If you find that the state has failed to prove beyond a reasonable doubt all or any one of the essential elements of the offense, or the defendant's participation in the offense, you must find the defendant not guilty. If you find that the state has proved beyond a reasonable doubt all the essential elements of the offense and the defendant's participation therein, and if you also find that the defendant has not established a defense of insanity to a preponderance of the credible evidence, then you must find the defendant guilty of the offense. If you find that the state has proved all the elements of the crime and the defendant's participation therein beyond a reasonable doubt, and if you also find that the defendant has established the defense of insanity by a preponderance of the credible evidence, your verdict must be not guilty by reason of insanity, and you shall so report and declare your verdict. A verdict of not guilty by reason of insanity does not necessarily mean that the defendant will be freed or that the individual will be indefinitely committed to a mental institution. Under our law, if you find the defendant not guilty by reason of insanity, it will then be for the court to conduct a further hearing and, among other matters, determine whether or not the defendant's insanity continues to the present and whether the defendant poses a danger to the community or to himself. The resolution of those issues will ultimately determine what appropriate restrictions need to be placed on the defendant. Thus, procedures exist to adequately provide for the defendant and to protect the public in the event the defendant is found not guilty by reason of insanity. Again, with regard to the verdicts, you may return one of three verdicts: not guilty. Number 2 would be guilty. Number 3, not guilty by reason of insanity. I will now give you some information on the final part of these instructions on conducting your deliberations. There is nothing different in the way a jury is to consider the proof in a criminal case from that in which all reasonable persons treat any questions depending upon evidence presented to them. You are expected to use your own good common sense. Consider the evidence for only those purposes for which it has been admitted, and give it a reasonable and fair construction in the light of your knowledge of how people behave. It is the quality of the evidence, not simply the number of witnesses, that control. As I said before, any exhibit that has not been marked into evidence cannot be given to you in the jury room, even though it may have been marked for identification. Only those items marked in evidence can be given to you. Very shortly, you will go into the jury room to start your deliberations. I remind you that during deliberations, and in fact, any time that you are in the jury deliberation room, you must keep any cell phone, pager, anybody use pagers anymore? Or other communication device you may possess turned off. You are to apply the law as I have instructed you to the facts as you find them to be for the purpose of arriving at a fair and correct verdict. The verdict must represent the considered judgment of each juror and must be unanimous as to each charge. That means all of you must agree if the defendant is guilty, not guilty, or not guilty by reason of insanity on each charge. It is your duty as jurors to consult with one another and to deliberate with a view towards reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous, but do not surrender your honest conviction as to the weight or effect of evidence solely because of the opinion of your fellow jurors, or for the mere purpose of returning a verdict. You are not partisans, you are judges of the facts. You may return on each crime charged a verdict of either not guilty, guilty, or not guilty by reason of insanity. Your verdict, whatever it may be as to each crime charged, must be unanimous. Each of the 12 members of the deliberating jury must agree as to the verdict. To assist you in reporting a verdict, I have prepared a verdict sheet for you. You will have this with you in the jury room. You'll have the indictment. I will give you a copy of my charge, a full copy of it so you can review the charge regarding any aspects of the charge that I gave you. And you'll have a copy of the verdict sheet as well. The form is to be used to report your verdict, and I did supply a copy of that to the state. Can you pull that up for us as I review it with the jurors? All right, just scroll up a little bit, please. All right, the jury verdict form lists count 1 as attempted murder, and it lists not the entire charge in the indictment, but a portion of it to help guide your deliberations. And count 1A is the attempted murder as to Lauren Kanarek, and it lists the possible verdicts: not guilty, guilty, not guilty by reason of insanity. If you answer guilty or not guilty by reason of insanity on question 1A, please go on to question 2A. If you answer not guilty, then you may go on and consider the lesser included offense of aggravated assault as set forth in question 1B. And that pertains to whether or not the defendant attempted or did cause or attempted to cause serious bodily injury to Lauren Kanarek. And again, the possible verdicts, if you reach that lesser included offense, would be not guilty, guilty, or not guilty by reason of insanity. Count 2 is the attempted murder charge as to the attempt to cause the death of Robert Goodwin. With regard to count 2, possible verdicts as listed: not guilty, guilty, or not guilty by reason of insanity. As with count 1, if you answer guilty or not guilty by reason of insanity on question 2A, please then go to count 3. If you answer not guilty on the attempted murder charge, then you can consider the lesser included offense of aggravated assault. And that's listed in question 2B, and again, your verdict's not guilty, guilty, or not guilty by reason of insanity. Question 3 pertains to count 3, possession of a weapon for an unlawful purpose, as it pertains to a purpose to use it against the person or property of Lauren Kanarek. Again, your verdict's not guilty, guilty, or not guilty by reason of insanity. And then you consider finally count 4 of the indictment charging possession of a weapon for an unlawful purpose to use against the person or property of Robert Goodwin. And once again, those verdicts are not guilty, guilty, or not guilty by reason of insanity. The verdict form that will go into the jury room will have a line for the signature of the person appointed foreperson. And when you have reached the verdict, the unanimous verdict, please, foreperson will sign the verdict form and advise the court officer standing outside that you have reached the verdict. Please do never advise anyone where you may stand with regard to your verdict. They should only hear that you have a verdict, and the foreperson will read that verdict in open court. If during deliberations you have a question or feel that you need further assistance or instructions from me, or wish to have certain testimony played back for you, please write your question or request on a sheet of paper and give it to the staff member who will be standing outside the jury room door, who in turn will give it to me. Court officer will be sworn to perform certain duties, such as keeping the jury together in a private place for purposes of deliberations and ensuring that no one speaks with you except by order of the court. You are not to discuss with or ask the officer about trial matters or procedures. Please be aware that the officer is also instructed not to initiate communication with you or to enter the deliberation room without your consent, except to communicate on my behalf regarding administrative matters, such as information about breaks or meals, or otherwise to ensure your comfort. If the officer must enter the deliberation room, the officer will knock first and complete the officer's responsibilities without delay. When the officer enters the room, please stop your deliberations and do not resume any deliberations until the officer has left and closed the door. Once I receive any question or request from the jury, I will go over it with the attorneys first, and I will try to answer it as quickly as possible, but please be patient in that regard. If you do not send out a question, or if you do send out a question, please do not disclose where you stand on deliberations. Never tell us, for example, that you stand 10-2 or 8-4 on a given charge. If you have reached a unanimous verdict on each charge, knock on the door, let the officer know that you have reached the verdict. Again, never tell the officer, and we'll bring you back into open court and we'll receive your verdict in open court. I have come to the end of my charge. As I said, I'll give you a written copy of my instructions along with the indictment and a copy of the verdict form to assist in your deliberations. Can I see counsel at the bench, please? Ladies and gentlemen, at this time we will select the alternate jurors. There will be 4 selected. My clerk's going to come over here. We have a box that the juror numbers only. Seat numbers have been placed in the box, so we will spin that box. And select the number.
Jury number 9.
All right, Mr. Wetter. Yes. All right, you're the first alternate juror.
One second.
Step in, they'll be sworn.
She's in chambers. Just grab Miss Kapka. Miss Kapka.
Oh.
Let's grab her.
Found her, Judge.
Sorry. Paper and pen.
She probably went to go get hair.
We have all the staff members that will watch over the jury room and the room where the alternate jurors will be housed. Please listen to the oath and respond accordingly. Raise your right hands, please.
Do you swear that you will do your best to keep every person sworn on this jury together in a private place, and that you will not allow any person to speak to them, nor to speak to them yourself except by the order of the court, and only to ask them if they have agreed upon a verdict until they have agreed?
I do.
I do.
All right, thank you all. All right, the staff members have been sworn. All right, members of the deliberating jury, you may now retire to the jury room to commence your deliberations. Very shortly, the computer and the evidence will be brought in to you to assist you, and you can review that during your deliberations. Thank you. And the alternate jurors selected can just remain in the courtroom for the time being. I'll have some further instructions for you. All right, be seated, everyone. Hi, Mr. Wetter, Ms. Chimento, Mr. Danhort, Mr. Jacobs, you're the